Amar, niyajibo.
2015 WPC of Anganwadi worker matter. Dismissal. Lots were taken.
Come on its own. Usual course. How many memos are you giving?
2015. Another memo.
No. Give one memo, please. Please, Mr. Mishra.
Yes.
Second offense for hearing. 2000.
It will come on its own. It is the usual.
5 and 2011 matter.
It will come in its usual course. The assignment begins from 2003. So naturally.
I am excused. Item number 20. Court number 10. Promotion matter.
No, not urgent.
Matter extension of time.
In anticipatory application.
Termination of government workers.
Yes.
See 2022 mallet.
Yes. They come in its usual course. It will come. It will come in its usual course. Yes.
Mallet of bail matter. Interim mallet. Mallet's bail matter. The matter is delisted.
Yeah.
Place admission transfer application.
What?
Tired of matter, because matter is kind enough to grant bail to all the 20 person and subsequently person has been arrested now in custody for more than a month. Maybe tomorrow.
Tomorrow, you will give to the
Lordship, there is an Anganwadi matter, Lordship.
What is the urgency?
Lordship, vacation of stay, Lordship.
Vacation of stay. That is not urgent. Yes.
Would you love the tired of matter?
Delay item number 1.
May pray, my lords, from lords, I may be permitted to make a mention, my lords.
ठीक है साहब
I beg pardon. Other list, my lord, item 4. My lord may not taken, so it may be transferred to some other thing.
item 4.
Okay, RS.
Release this matter before any other bench as I am concerned.
Item number 29, my lord.
Yes.
RSA number 106 of 22. I have taken consent of the respondent matter to lordship may call this matter 1 week after 1.
2022.
22.
It is in the weekly list.
Yes, ma'am.
Today it is not going to reach.
Mr. Asudas has gone off.
So no. Let it reach. I will pass. I will fix a particular date.
Yes, ma'am.
After hearing both sides. Yes.
Lords, item number 14, it has not been admitted, but the respondent has entered appearance. So I pray, lords, at least 10 days time, so I'll prepare a note, lords.
No. Let it reach. Let it reach. You will see.
Yes, matter, my lords.
Let it reach. I will adjourn it. Don't worry. Yes. Yes, Mr. Bera.
May I it's on paper transfer for CMC case number 16 of 2022 pending before the loan and judge family court Jharsuguda to loan and family court Bhanjanagar minor. Due to the present petitioner is the wife and filed the 125 petition before the loan and family court to Jharsuguda and the 2 children minor and a surface 1 7
Where is the husband residing?
ସେ ହଉଛି ଆଜ୍ଞା ସେ ଝାରସୁଗୁଡାରେ ମୁଁ ହଉଛି ଭଞ୍ଜନଗରରେ ମୋ 2ଟା ଛୁଆ ପଢୁଛନ୍ତି ଆଜ୍ଞା petition 2 and 3 and so 7 and page 7 and 8 my can see the school admission register man 7 and 8 वो हଉଛି answer 1 page 7 8
Already issue notice to the opposite party. A speed post fixing a short returnable date. The requisites be filed by tomorrow. Peremptorily.
3 days.
No. Speed post tomorrow. Release this matter. 16th July. In the meantime, if an application for adjournment is moved on behalf of the petitioners in CMC case number 16 of 2022, the court below shall consider the said application having regard to the date fixed for hearing of the present case. Yes. I don't know what to.
This application is at the behest of the wife, my lord.
Yes.
The wife seeks transfer of the MAT case from the file of the learned my lord, Civil Judge Senior Division Rajgangpur to the.
There was a direction earlier for to take part in the conciliation proceeding.
My lord.
There was a direction by Justice G. Satpathy on 16/2/2024. It is the order is, it is informed by Mr. A. Mr. Learned Counsel of the petitioner that immediately after receipt of notice, the petitioner has filed the present application. But the court is of the considered view that the petitioner should participate in the conciliation proceeding at the first instance. Accordingly, the petitioner is directed to take part in conciliation proceeding pending disposal of the transport. What happened to that?
That conciliation proceeding is at Rajgangpur, my lord.
So what happened to it? There is a judicial order. There is a judicial order.
That I have to take instruction whether.
Take instruction. Let's see, Origin Mr. Learned Counsel appeals for the petitioner wants to take instructions from his client. In respect of the order passed by this court on 16/2/2024. Release this matter, what short date court? Next week. 25th June. Obliged.
Item number 3. May I please, your lordship, the petitioner wife filed the petition for transfer of the CP proceeding from Judge Family Court Fulbani to Bhanjnagar, Civil Judge Senior Division,
Kulbani to
Bhanjnagar, your lordship.
Bhanjanagar.
Husband filed the proceeding for divorce, your lordship, in Fulbani, wife residing in Bhanjnagar. For that reason,
Wife is residing at Bhanjanagar.
yes, your lordship.
Where have you said that?
Your lordship,
Paragraph?
I am stating here. Your lordship, that is page 9 petition of Hon'Ble sir, she is feeling not safe, travel just from the full band page posting. Page 5, your lordship.
Page 5.
Page 5, para 9 and 10, your lordship.
All right, take notice, issue notice to the opposite party by speed post. Fixing a short returnable date, requisites be filed by tomorrow, peremptorily. Place this matter on 16th July, IA. Say order koto. Adjournment.
Obliged. Article.
Item number 4.
May petitioner is the
Handle.
my prayer only. My prayer only the consideration of the representation annexure 5 series.
Matter consideration of the representation. This is not that kind of a court, you know. I'm not interested in disposal. You must tell me what is the fact. I may still dismiss your application.
Let's
You
say
never know.
fact is the petitioner is the
Yes.
petitioner is the application file this application for a representative capacity we SCST community of Firingia block Kandhamal district.
Petitioner is a
Petitioner is the secretary of the Kui Samaj. That's it. He is the representative capacity in the SCST community of the Firingia block under Kandhamal district. Only the petition file the.
So this is in the nature of a PIL.
No,
This is in the nature of a PIL.
that is the that's it, the only the harass of the Kui SCST petitioners or
This is not maintainable. This writ application itself is not maintainable. In a representative capacity, if you file, you may file a PIL if you want. You may file a PIL. Or you may, there's no stopping you from approaching the authorities, withdraw the writ application.
that's it, the only the harass of the SCST.
Maybe first it has to be maintainable. Then only this court can pass any order.
That's it, the
Yes, what do you say?
It's a class action suit. Secondly, it's a merit list of 2006.
In any case, it's a class action suit.
Yes.
maybe the adjournment
Maintainability examine kari na thi.
and maybe pass adjourn the.
Adjourn kar debi, but maintainability kari na.
Yes, satisfied.
Class action suit. Or in a representative capacity. Portraying, containing or involving rather individual grievance. It's not maintainable. PIL, yes. For whatever worth you may file a PIL. Individual grievance kon achi kon. That could be considered. But you have come in a representative capacity.
Individual grievances.
Read the book, Read Jurisdiction under Articles 226 and 226 of the Constitution by B.L. Hansaria, Justice Hansaria, as his lordship then was. All right.
Adjourn the
Huh?
matter
केबे कोई खाली
next week.
All right.
Next week any day.
as requested by Ms. Anima Kumari Dei, learned counsel for the petitioner, is this matter next week. Prepare. जोटा maintainable हो सेटा करिया नो है काई करे.
I don't know if I.
The petition said the appointment of the official township at Anganwadi occur.
Sir, can you please adjust the mic? It's not because of this fan, it is not audible. Public notification is to engagement, resident certificate is to engagement.
Anganwadi worker appointment, that is,
You are appointed as Anganwadi worker?
no, I am challenging the appointment of opposite pet number 6.
Yes.
Anganwadi worker, mainly on the ground that he is not a native. That is.
So there is alternative remedy. There is alternative remedy.
Alternative, I have already submitted Annexure 6.
Annexure 6.
Before the opposite pet number 3.
All right. Let us
That
see.
will be considered.
Sub-collector is the
That is the appellate authority.
sub-collector. How?
My lord.
Well,
My lord, appointing authority is the, already appointment order issued by the CDPO. That is Annexure 3, page 12.
no, this is 2022. This is prior to coming into force of the revised guidelines. Revised guidelines came in 2023. 23. I have a copy, of course. So 2022 pending achievement. This is, I think it will be the ADM. It will be the ADM, not the sub-collector.
And let's say 2022 is the-
देखो ना तो 2022 में सब-collector थे बोले देखो ना तो hey अंगनवाड़ी बोल बात कर अंगनवाड़ी क्या है क्या where is the book where is the इच्छी पढ़ी है खाली तरह से चल 2007 will apply isn't it so I think the ADM is the authority.
Sub-collector is the selecting authority.
selecting authority, subcontractor,
Yeah.
Dependence, I will file a press dependent for the ADM mail.
Yes.
So that will be director mail.
Within time there are limitation there are limitation there is some limitation even ADM will be the appellate authority for hearing complaints regarding selection of Anganwadi workers.
2006. In 2006, there was a.
No, so that was revised.
2007, I was.
All right.
And press dependent file.
All right. Learned counsel for petitioner and learned. You are AG or AC? AC. Your good name, sir?
Lolatil Samar.
Heard Sri Lolatil Samar, learned counsel for the petitioner, and Sri. You are P. Behra.
Arnav Behra.
Arnav Behra. I'm sorry. Sri Arnav Behra, learned additional standing counsel for the state. The petitioner has approached this court seeking the following relief. The case of the petitioner, briefly stated, is that she was an applicant for the post of Anganwadi worker in Anganwadi bracketry mini center at Bangamunda in the district of Balangir. As per advertisement dated 30/6/2021. It is a grievance that the selection committee acted in violation of the selection guidelines and appointed one Kontana, one Sarita Putel, PUTEL, bracket opposite party number 6, as Anganwadi worker of the said center. It is submitted that said Vanita Putel is not a resident of the service area of the Anganwadi center in question. Highlighting her grievance, the petitioner submitted a representation on 3/1/2022 addressed to the sub-collector Titlagarh. No action appears to have been taken on such representation as yet. This court, however, observes that as per the revised guidelines for selection of Anganwadi workers, the additional district magistrate shall be the appellate authority for hearing complaints regarding selection of Anganwadi workers. Stop. At this stage, Sri Samal Learned Counsel for the petitioner seeks a liberty of the court to approach the ADM Bolangir by filing an appeal. Stop. Sri Behra Learned State Counsel fairly submits that the ADM being the appellate authority is competent to hear any appeal relating to engagement of Anganwadi workers. Stop. Having regard to the submissions and facts stated above, the writ application is disposed of, granting liberty to the petitioner to prefer an appeal before the ADM Bolangir within 2 weeks from today. Stop. If such appeal is preferred within the time stipulated, the ADM Bolangir, being the appellate authority, shall dispose of the same in accordance with law. That's all.
Your Lordship may only add that the opposite party number 6 may also be granted.
After granting opportunity of hearing to all concerned, including the selected candidate. That actually goes without saying, but
Safer to add.
yes, yes.
Within 2 months.
The further, the appeal shall be disposed of within a period of 6 weeks from the date of its filing. I don't know, 6.
Maybe.
Dhananjay Charan.
No.
It's covered by that Dhananjay Charan.
We'll pass that order.
Yes, ma'am.
Dear.
6 and 7.
Has the government not come up with any notification? In the individual you are saying that the government will come up with a notification?
But after going through after verifying the different kind of certificates which are required, my lord. Now about 97 or 98% cases were under scrutiny.
So, this does not actually, this will make the process a little bit cumbersome, tedious also. Unless they come up with a single notification covering everybody, which will be considered by the grassroots level officers.
That was the information with me, my lord, prior to vacation. So
much has changed after vacation.
6 and 7 were same.
Again?
6 and 7 also same.
6 and 7 are item
6.
Item 6 gala. 7 gala.
7 also same.
7 be same.
No.
All these matters.
All these are same.
Yes, Mr. Baker. All.
I have also corrected the beginning.
Item number 8.
Number 8 on for Mr. J.K. Lenka, Lordship kindly action. Next week.
This is a partner matter.
But is relative on the matter of an accident. That's why telephone.
Side? Anybody? Any private party? He wants time.
Yes.
All right. Prayer for adjournment is made on behalf of Sri J.K. Lenka on the ground of bereavement in his family. Let's this matter next week. Next week में Monday कर दो. Monday को आरंभ आज मंगलवार अच्छी ना, है ना? Monday को किसी अच्छी क्या हमरो? ना. हैं? ना Saturday की तरह. I'll adjust it. Either Monday or Tuesday.
After hearing the matter, it was only fixed for 2 days. And judgment at Dihavani.
अब तो ये खाली देखी दिले मोरो ठीक देखी दिले. I knew I did not. I kept it before. Otherwise, my vacation would have gone. Huh? I don't know 9.
Item 9 to appreciate annexure 3, the impugned order, your lordship wanted to have the director's entire
Let me see. What is the order? This court is of the view that the records of the proceeding before the director are required to be verified in order to ascertain the specific stand taken by each of the parties. Director to transmit the case. So the case record has come.
No, it has not come. Your lordship may give me a week's time. The director has retired in the meantime. And because of the intervention of the election of that.
So some document was filed before the director that was contempt.
Yes, your lordship. The dispute is the intent of the governing body before the director was that I was never being appointed.
All right. Sri Ardas Landeji requests for a short adjournment on the ground that the director higher education, the incumbent director higher education having retired in the meantime, the records could not be obtained as directed by this court.
Inward director posting ହେଇଛନ୍ତି sir. Inward director ହେଇଛନ୍ତି.
Lekhi भी सेटा Mr. Pratap submits fully. Let's this matter next week. The order, previous order be complied with positively.
A week after.
यही देखो.
Inward director अपन
2nd July. All right. Let's just matter on 2nd July.
Okay.
Previous order be complied with positively. Item number 10. ये काम करें नहीं? पलावले लागू तो लिखे. हाँ, कुल. नहीं री. नहीं. Item 10. Is the pattern matter?
Yes, Parag. Well, I'll just show to your lordship as 4 orders. Lordship may first see the order of the 21st of October 2022, my lord.
21st October.
Order number 9.
October.
21st October 2022, my lord. Order number 9.
Yes.
Mr. Mahapatra, under Standing Counsel for the School and Mass Education Department, submits that he has obtained instruction to the rejoinder affidavit. Will file the affidavit by 26th of October after serving copy thereof. My lord. And then lordship kindly see order dated, my lord, 7th of December 2022. No, that lordship may skip over 12th of my lord, 3rd January 2024, my lord.
Yes.
On the prayer of the Learned Council for the state lists this matter on 31st January. Learned Council for the state is requested to place on record the certificates of BPE as well as BPED along with the courses, since it is agreed at bar that the same is essential for the just adjudication of the case at hand. Interim or to continue. Then, my lord, lordship will see order number 14.
Yes.
28 to my lord, passed by lordship. A stand has been taken by the state in this case that BPED is not higher qualification than CPED. In course of hearing, State Council submits that he would file an affidavit after obtaining necessary instruction with regard to the status of both the qualifications from the university. The State Council further submits that he shall also indicate the position vis-a-vis the petitioner's qualification. List this matter and so interim order to continue. Then lordship may see the last order, that is 7th of March 2024, ballot.
Yes.
This matter is taken up in hybrid mode. The affidavit as directed has been filed by the state. London State Council requests for an adjournment. Affidavit, if any, be filed positively, failing which the matter shall be decided on the basis of the available pleadings. And the whole contention of the state that BPED and BPE are different, and BPED is not higher than CPED. Not this, I have no quarrel with regard to that, but with regard to BPED, BPE, I have. But with lot of effort, I could get. What is BPED and BPE? And what is CPED?
Why don't you file it by way of an affidavit?
Well, it's not required. Not required, well. It's only at the behest of the state, certain things are stated. Well, the advertisement is that he has to have a minimum qualification of CPED, well. And if anybody is having higher qualification, then that higher qualification mark will not be added for the purpose of consideration as to whether it will be given a permanent or not. On this issue, every time there is some arm twisting. With due respect, I would submit. Lordship will see what is BPE, what is the meaning of BPE and BPED. It's same. A Bachelor of Physical Education BPE or BPHED is a bachelor degree granted by some universities. In many Canadian universities, it has been replaced by the Bachelor of Kinesiology. The degree can include topics such as sports science, coaching and outdoor education. In India, Bachelor of Physical Education degree is known as BPED or BPE. There is no dispute regarding that, Malad. And what is CPED, Malad? It's a certificate in physical education, abbreviated as CPED. Is a one-year course that is studied after the higher secondary education 10+2. Many colleges and universities offer the certificate in physical education course in India. Every college has its something wrong with its own eligibility criteria, admission process, and fee structure. The fees, blah blah, they're not required. And now what you kindly see in this case, what is the Malad advertisement? It is Malad at page 29.
29.
Yes.
I think, are you referring to this one?
Yes. Malad, middle column, Malad. Lordship, I can see the 24th line from the top.
Yes.
In
case of PET though?
Yes.
Huh.
In case of PET, a candidate should have a minimum matriculation with CPED qualification. Done, Malad?
You have that qualification?
I have BPED, Malad. After graduation, the person having both degree, well, now I have shown you Lordship, it is CPED is 1 year. Degree, Malad, I have obtained 3 years. The person having a degree in postgraduate degree in professional qualification can apply to the post of PT, but for the purpose of computing their peer marking, the minimum academic qualification are to be taken into account along with the marks obtained, both either in diploma, degree and postgraduate professional qualification in physical education, but not higher academic qualification.
Yes.
Now, Lordship, they kindly see my qualification, our qualification, Annexure 1 and Annexure 2, Malad. Lordship will see, Malad, at page 16.
Page 16.
Yes, that first, the petition number 1 is passed out. Bachelor of Physical Education 3-year course in first class. And prior to that, Malad, I have annexed my testimonials with regard to having passed out the graduation course. Malad. And at page, Malad, 25, it is the certificate of the petition number 2. Bachelor of Physical Education, 3 years course, first division. And now, Malad, based upon the advertisement, when we applied, Malad, Lordship will find our names figured at Lordship at page 30.
Yes.
That is provisional merit list for the engagement of contract teachers, so and so. And Lordship may kindly come to Malad at page 32.
Saritarani Pusti.
Yes, Saritarani at the top and at the middle, serial 45.
Sanjuktabad.
And then, Malad, the rejection at impugned order at page 33.
33, yes.
Yes.
Untrained.
Malad, they say untrained. How it is, I don't understand. And in the Lordship, I see in the counter affidavit, Malad, what they say is, Lordship may kindly see from page 43. Now, I'll read 3 paragraphs.
Yes.
Paragraph 5. As per the advertisement, the qualification fixed in the case of PET is that a candidate should have minimum matriculation with CPET qualification. They just replicate what is there in the advertisement. the person having both degree and postgraduate degree in professional qualification can also apply to the post of PED, but for the purpose of computing their career marking, the minimum academic qualification have to be taken into account, along with the marks obtained both either in diploma, degree, and postgraduate professional qualification in physical education, but not higher academic.
This I don't think you are disputing because they're
Exactly, they're replicating what is there in that
in that.
Then 6. It is humbly submitted that one candidate should have passed minimum academic qualification of matriculation with CPD. I have. CPD is blood, just a certificate. It's a 1 year after blood intermediate or +2. Higher qualification is also permitted. Although the person having both degree and postgraduate degree in the professional qualification can also apply for the post of PT, but for the purpose of computing their career marking and minimum academic qualification are to be taken into account, along with the marks obtained both either in diploma, degree, and postgraduate professional qualification in physical education, but not higher academic qualification. Since the present petitioner has not acquired CPD qualification, which is the minimum qualification, is not eligible. How it is? It's preposterous. If I'm having a higher qualification or a qualification or having a professional degree, the language is professional degree. Lordship knows that 1979 Supreme Court, page 1628, Airport Authority case. In paragraph 7, Honorable Supreme Court has specifically stated that you cannot add superfluity to the language deployed in the advertisement. It has to be understood as it is, like as a statute is understood. So if you understand the advertisement,
Is that, are you referring to that Ramana Dayaram Shetty versus?
Exactly. That's better. And if that is so, I have the qualification. How am I disqualified? And the Lordship sees the reasoning given in paragraph 6. It is preposterous. The reasoning, so the reasoning that is opposed to what is the advertisement. And that is the reason, my lord, they have been state is taking time on various occasions. BPE, BPED different. We collect information from the university. And every time they are seeking adjournment on this particular, and so far nothing has been filed, though last charge has been fixed. And again, Lordship can see paragraph 7 at page 44.
Yes.
That the present petitioners have acquired BPED qualification, but BPED qualification is not higher qualification to CPD. Well, I don't say that. I don't claim that because I am having BPED, I am having higher qualification. Give me more mark. You are saying that I am disqualified because I am untrained. How am I untrained? You don't say that, no, you don't justify your eliminating me on the ground of being and now I can see what is there. For taking admission in BPED course, it is not necessary that a candidate must have completed CPD course. I don't understand what they mean by this sentence. For taking admission in the BPED course, a graduate in any stream can apply for the same, and the BPED qualification cannot be treated as higher to CPD. Let me pause here for a moment. I don't claim that BPED is higher than CPD. It says that minimum I should have matriculation with CPD, and higher qualification can be. You equate me with CPD. I am higher. It's a degree, 3 years degree, Malad. And I have shown to your Lordship what is BPD and what is CPD. And now, Lordship may kindly see, in my rejoinder affidavit, I, Malad, have filed, after getting, Malad, an information from the RTI, that was similarly treated, Lordship, at page 51, Annexure 7.
Yes.
Malad, the RTI applicant is, Malad, the petition number 2. And in this, Malad, Lordship will see, as at page 53, the public information officer writes, with reference to your RTA application cited above, I am to inform you that your required information is to be prepared and sent to you. Hence, you are herewith requested to deposit 50 rupees. I deposit immediately thereafter at page 54, Malad. Then the deposit is there at page 55. Then Lordship will see at page 56. The PIO writes, in obedience to the provisions laid down under section so and so, you are hereby supplied and the required information in 6 separate sheets. But now this gentleman, Rabindra Kumar Raut, having the very similar qualification as of the petitioners, identical qualification, was given appointment.
You have any interim order in your favor?
Yes. He was given appointment.
What is that CPET qualification of BPET qualification of this gentleman? Yes. Page 60 probably.
Yes.
All right. No,
page 60.
how do you know that he was given appointment?
Well, I have stated it in my rejoinder, my lord.
All right.
Not denied.
Yes.
And now, my lord, an affidavit was sought to be filed, and that affidavit has page 63, my lord.
But that is a affidavit filed prior to my order.
This is also after one of the orders, but prior to the order.
Yes.
I so and so, my lord, that in the year 2012-13, an advertisement was made for the post of contractual teachers, including the post of PET in different districts. In the said advertisement, it was instructed to the eligible candidates to submit their application form before the concerned district education officer.
We can skip it. We can skip. Yes, yes, let us skip. I mean,
yes. Then para 5, my lord.
Yes.
As directed in the order of 21st of October 2022, that is the first order to I showed to your lordship, my lord. By this honorable court, the deponent begs to submit the following paragraphs 5, 6, 7, 8, not discussed. Then it is not agreed that BPED and MPED, well, there is no question of MPED, MPED they have included here. BPED and MPED are not higher qualification of CPED. It is not possible to accept the statement in rejoinder in para 5 that the opposite parties have filed counter affidavit without understanding the full form of the abbreviation CPED. Well, there is no qualification as was required to be submitted by them, my lord, on the basis of the my lord, order of this honorable court, and the order got emanated because of at the behest of the State Council. Then Roman 3. The statement in para 3, paragraph 6 that BPED is nothing but CPED is not agreed to. Both are related to training in physical education. Now I come back to the advertisement. Professional qualification. The advertisement says professional qualification. Now this qualifies to that. But the syllabus and object of the course are different. But how it is not to somebody has to now suppose an advertisement for the particular post of lecturer somewhere. Well, I pass out from our local board, that is matriculation. Someone passes out from ICSE, someone from CBSE. Is it that the course in all the 3 are same? CBSE, ICSE different, matriculation different. But can such a plea state? Well, state is to act for the benefit of the citizens. State cannot act as a private litigant to vindicate the wrong that it is committed. The course is designed for different age group of students, although both courses have many common teaching points. Then, over the page, next page, as regards the submission in para 8 of the rejoinder, Rabindra Kumar Rao to similar qualification has been appointed in Gajapati district. Open number 2 has nothing to differ straightway. Admit. As the selection of 12-13 was made at district level, the intricacies of decisions needed to be thoroughly probed before making any statement. How can this is purely Article 14 and 16. In the state of Orissa, in one district, you will follow one modality. In other district, you will follow another modality. Then there are various laws in one state for various districts. You send Article 14 and 16 to the wind. But the fact remains, apart from the degree and diploma, there are other factors like documents actually submitted with the application, equivalency, recognition of the course, other eligibility conditions, etc. for making to any selection, instead of pleading for negative equality with Ravindra Raut, the petitioners may justify their claim on merit of hearing. Is it a negative equality I'm claiming? But is it the concept of negative equality? Somewhere when we qualify, right, we cannot be taken out of the zone of consideration on the ground of being untrained.
Yes, Mr. Patnaik.
First of all, my lord, the directions which were
Issued long ago with a specific order that no further adjournment shall be granted. How are we at this? It's too late in the day.
That is what my lord, now
I may not refer to this because this is Wikipedia. If you could have come up with an affidavit, at least I could have taken it on record. Otherwise, simply referring to Wikipedia, you know, Wikipedia can have a lot of evidence is there, may be accepted. But Wikipedia being Wikipedia.
It will not be accepted if something contrary to this has become submitted. With all my effort, I could find this. That is in the website.
It would have been better if they could have filed an affidavit. Anyway, they have not filed an affidavit. We'll see what is
filed an affidavit saying that it is not.
You have filed an affidavit.
That instructions while referring to that 22. Just
So
now
you-
it has been
yes. That will suffice.
Yes.
Anything
That is
else?
what we have stated.
Yes.
My lord, our submission is that, my lord. The selection has
This,
been made.
let us make it clear. These two petitioners have a qualification.
Of BPE.
BPE or BPED. No, BPED होती No, no.
BPED. But I think, my lord,
No, you
Dr.
look at the
Singh will
certificate.
agree with me that it is BPE.
What is DPAD? EAD same.
No, I have read somewhere. Bachelor of Physical Education.
Somewhere ED for education, somewhere E.
Doesn't matter. Nomenclature doesn't matter. But anyway, they have a bachelor's degree in physical education. Isn't it? Now, the minimum qualification is matriculation with CPED. They have something which is higher than CPED.
That is not, that is what we have submitted. Now it is for lordship to appreciate. We have categorically stated in his own rejoinder also, my lord. In paragraph number 6, they have also stated that we have never claimed that it is higher. We are saying that it is not higher. And they are admitting in the rejoinder also, my lord, that it is not higher.
In the argument, it said so.
So if it is not a higher qualification, and if he is not possessing the minimum qualification, then in that case, my lord, we rejected on the ground of conflict. That is our limitation.
But there is another aspect which is that Ravindra Kumar Rao.
Yes, ma'am.
The identical qualification he has been granted upon.
That is what we have, my lord, clarified in that particular affidavit. Later on, my lord, after the documents were produced to that effect, saying that, my lord, that it is just like claiming a negative equality because that particular person, a wrong, if it has been committed at a.
You have never said that he has been wrongly appointed. Unless you specifically say that he was wrongly appointed or appointed dehorsed the rules. And so he cannot claim the negative equality. You have not said that. You have left it to be imagined by the court. Why will the court imagine?
That is what it is not. It is
anyway, hearing concluded, judgment reserved.
Yes, sir.
Parties may file their note of submissions and memo of submissions if any within a week or within 3 days. Within a week. Within a week.
Yes.
Okay. Item 11. Yes.
Matter your lordship, asked me to file a rejoinder. I have prepared that my deponent has some problem, has not come, 2 days time may be given, so next Monday. It is a matter relating to advertised salary not paid.
I know.
Yes.
My lord, I am from OP number 2, 3 and 4.
Yes. See, B.S. Das, Learning Counsel of the petitioner permits that he has drafted a rejoinder to be filed within a couple of days and requests for an adjournment. Let's this matter.
Monday.
Next week? No, Monday.
Monday.
Rejoinder if any be filed in the meantime. After serving copy on the other side.
Oblique.
Item number 12.
maybe. But in this matter, the petitioner has retired during penalty of the writ petition. So therefore, I would like to make an amendment to the prayer of the writ petition. So I'm filing a IE, a short copy. So Lordship will allow it to file a consolidated petition.
Just now I received the copy.
You are filing a petition for amendment. You want to object?
Yes, my lord, it is better, I studied. My opinion is that instead of making an amendment, let him file a fresh application if he show claims. Because now in the meantime, it has already become infructuous, the prayer that has been made in the writ petition. So that is why my lord asked him.
Well, the court cannot advise. Mr. Panda, the court cannot advise.
That was discussed.
So what is
For him to file,
whatever he is filing on his representation on instruction, he may be filing, will be misunderstood. Let him file for whatever you may file objection.
it has not been numbered. Now
No.
it is just filing.
No, I will just keep it, I will register it, and you have received a copy.
I have just.
All right. Sri P.K. Ryle and counsel for the petitioner files an IA with prayer for amendment of the writ application. After serving copy on the other side, stop. The IA be registered. Let's just matter next week. Next week though. Because this is a parted matter.
Because I will ask the use the authority to file any objection or not.
See, Ponda.
One week after my set.
अच्छा तो तापर week कर दे. 2nd July. हैं? 2nd July. Let's just matter on 2nd July. Objection if any to the IA be filed in the meantime. Yes. Parted matter सरला. Yes. Yes, Mr.
This is regarding challenging the selection of Asha. Lordship, the last officer.
Mr. Please adjust your mic. The fan ta bulchi to shubho nisit. What is the matter about?
Relating to appointment of Asha, we are challenging that selection.
What is your prayer? Let us see your prayer.
Last occasion, your Lordship, in absence of the council.
Selection of So you are challenging the appointment of opposite party number 5. Who is appearing for the private opposite party?
Mr. Kuresh Prasad Das.
Kuresh Prasad Das. Mr. Kuresh Prasad Das. If he doesn't appear, come for let us begin. Let us begin today. If he comes, I'll keep it parted so that I'll grant him another opportunity. All right, you begin.
The petitioner challenging selection and appointment of opposite partner 5 as Asha at Patabarana Anganwadi Center, Patabarana under Lodhachua Block District, Nayagad, and praise for passing of the selection and engagement of opposite partner number 5 by the Annexure 11 series. Lordship kindly turn to that we have got some documents under RTI, which is neither she is qualifying to be a candidate in the selection.
You are one of the applicants.
My lord. Your lordship kindly.
Yes, please.
Again, serial number 4 is the present petitioner.
Nirmala Behera.
So for age is concerned, that is
25.
Again, that is in accordance with the guideline. And 10th pass is more than the qualification fixed for the not coming within the zone of consideration only because the age has been fixed 25 to 45. And she has been selected.
Where is the advertisement?
That page 17, annexure 1 in the written application.
ତାଙ୍କର ବୟସ 25 ରୁ 45.
ଆଜ୍ଞା ସେ ଗାଇଡଲାଇନ ଟା ବି ସେଟା ଇଂଲିଶ ରେ ଦେଇଛନ୍ତି ମାନେ ପାର୍ଟ ନମ୍ବର 3 CDM in their counter affidavit. ସେଟା ଟିକେ ଦେଖିଲେ ଭଲ ହବ.
ଆଶା ଚୟନ ପ୍ରକ୍ରିୟା ସଭା ବିବରଣୀ
ଆଜ୍ଞା।
ସେଗୁଡିକ ଆସିଲେ କଣ ଲେଖାଯିବ?
କରେକ୍ଟଲି ଦେଇଛନ୍ତି ଇଂଲିଶ ରେ ସେ ଏଟା ସେଟା annexure A by 3 at page 5 in the counter affidavit filed by the opposite party number 3. ଆଜ୍ଞା page 6 internal page 2
Yes. ପଢନ୍ତୁ।
criteria for selection of Asha. First criteria is Asha must be primarily a woman and resident of the village. Second, she should be preferably in the age group of 25 to 45. Third qualification, she should be the literate woman with formal education up to class 8. She is not qualified because only age is 22. And moreover, selection is also behind back of the selection committee. That is, they have admitted. So Lordship, kindly see their counter affidavit opposite party number 3
Yes.
at page 10. Page 10. Sorry, my lord, page 8. Annexure B/3.
Yes.
ପ୍ରସ୍ତାବ ନମ୍ବର 1 ଆଶା ଚୟନ ପ୍ରକ୍ରିୟା ପାଇଁ ମହିଳା ସ୍ୱାସ୍ଥ୍ୟ କର୍ମୀ ଆଣିଥିବା ପ୍ରୋଫର୍ମା ରିଜଲ୍ୟୁସନରେ ଉପସ୍ଥିତ ଥିବା ସମସ୍ତ ସଭ୍ୟମାନେ ସ୍ୱାକ୍ଷର କରି ଉକ୍ତ ରିଜଲ୍ୟୁସନର ଜେରକ୍ସ କପିର ଏକକିତା ନକଲ ଅଙ୍ଗନବାଡି କର୍ମୀକୁ ଦେବା ପାଇଁ ନିଷ୍ପତ୍ତି ନିଆଗଲା। Behind back they have selected. ସେ ପ୍ରୋଫର୍ମା କରି ଆଣିଥିଲେ ସିଲେକ୍ସନ 10 କରି ନେଇ ଚାଲିଲେ। And next page you will also
7 and 8 of the counter, which has been, the selection has been by way of a lottery. Paragraph 8.
No, but if somebody does not have the age qualification, କେମିତି ହବ? 25 ରୁ 45 ରହୁଛି ନା?
Yes.
And you don't dispute that she was aged 22 years.
That mistake must have cropped up because of the lottery, that mistaken information.
ନା ଲଟେରୀ ସିଲେକ୍ସନ ହବା କଥା କୋଉଠି ଅଛି?
ଗାଇଡଲାଇନ ଅଛି। ଗାଇଡଲାଇନ ଅଛି ସେଟା ଅଦର ପର୍ପସ ମାନେ ସିଲେକ୍ସନ କମିଟି ମାନଙ୍କର ଅନାନିମିଟି ଆସିଲାନି ତାଙ୍କ ଭିତରେ କିଛି ପ୍ରୋବ୍ଲେମ ହେଲା then lottery will be adopted.
Normal course
here they have କଣ ସେମାନେ କହୁଛନ୍ତି ଯେ ଏଇ ଦି ଜଣ ପାର୍ଟିଙ୍କ ଭିତରେ ଗଣ୍ଡଗୋଳ ଲାଗିଲା ବୋଲି ଆମେ ଲଟେରୀ କଲୁ, which is not as per the guideline.
All right, then let us wait for the take it up next week ଆଉ କଣ କରିବା?
ଆଉ ଗୋଟେ ମାନେ ଇମ୍ପୋର୍ଟାଣ୍ଟ ଥିଙ୍ଗ ଅଛି, ସେ ଯୋଉ ସାର୍ଟିଫିକେଟ ଟା ପ୍ରଡ୍ୟୁସ କରିନଥିଲା ସେତେବେଳେ ଅଷ୍ଟମ ପାସ୍ ବୋଲି ଲେଖା ହେଇଛି, ତାର ଯୋଉ ଡାଟାଟା ଦେଇଛନ୍ତି ଆରଟିଆଇ ରେ ଅଷ୍ଟମ ପାସ୍ କରିଛି କି ନାହିଁ ମୁଁ ମାଗିଲି ଆରଟିଆଇ ରେ, ସେ ମତେ ଦବା ପାଇଁ ଗୋଟେ ମ୍ୟାନୁଫ୍ୟାକ୍ଚର କରିଦେଲେ ଡକୁମେଣ୍ଟ ତାକୁ ସାର୍ଟିଫିକେଟ ଦବା ପାଇଁ। ମୁଁ 15/2 ରେ ଆପ୍ଲାଏ କଲି, ସେ 9/2 ରେ ତାକୁ ଦେଇଦେଲେ ଏବଂ ତାରି କପି ମତେ ଦେଇଦେଲେ। ଟିକେ କାଇଣ୍ଡଲି ଦେଖିବେ କି ସେଟା
ପେଜ
ମୋର ସେ ବି ଫାଇଲ କରିଛନ୍ତି ତାଙ୍କର ଅପୋଜିଟ ପାର୍ଟ ନମ୍ବର 5 has filed in their counter page 3. Annexure 6/1 or C/1 perhaps. C/1. Counter filed by the opposite party number 5.
Yes. Transfer certificate.
ଆଜ୍ଞା ସେଟା ଦେଖନ୍ତୁ ଲାଷ୍ଟ ଲାଇନଟା ଅଛି, ଲାଷ୍ଟ ଡେଟ୍ ଗୋଟେ ପଡିଛି 9/2/2008। ମୁଁ ଆକ୍ଚୁଆଲି ଆରଟିଆଇ ରେ ତାଙ୍କ ସାର୍ଟିଫିକେଟ ଟା ମାଗିଲି 15/2/2008 ରେ। ସେ ମ୍ୟାନୁଫ୍ୟାକ୍ଚର କଲେ ଡକୁମେଣ୍ଟ ତାକୁ ଦେଇଦେଲେ 9/2 ପକେଇକିରି, ସେଇ ସାର୍ଟିଫିକେଟ ଟା ମତେ ଦେଇଛନ୍ତି। ଟିକେ ଦେଖନ୍ତୁ ଆଜ୍ଞା ଫୋଲିଓ ନମ୍ବରଟା ଟପରେ ଲେଫ୍ଟ ଫୋଲିଓ ନମ୍ବର, ଯାହା ଫୋଲିଓ ନମ୍ବର ଅଛି ସେଇ ଫୋଲିଓ ନମ୍ବରରେ ଅଦର ସାର୍ଟିଫିକେଟ ବି ଇସ୍ୟୁ ହେଇଛି ସେ ସ୍କୁଲର ପ୍ରାୟ ପିଛିଲା ବର୍ଷରେ 2007 ରେ ସେଇ ଫୋଲିଓ ନମ୍ବର ଅଛି, 2008 ରେ ଏଇ ନମ୍ବର ଆସିବନି। ମୁଁ ସେଟାକୁ ବି ଦେଇଛି ମୋର କାଗଜ, ମୁଁ ରିଜଲ୍ଟ ଆଫିଡେଭିଟ ରେ ଦେଇଛି ପେଜ Page 13.
Well, let the other side come. But in part. The Mr. Counsel of the petitioner is present. Mr. Counsel of the petitioner and Sri A.R. Das, learned AGA are present. None appears for the opposite party number 5. Heard in part. Let's this matter next week. Next Monday, as you. Yeah. Last time, it's Tuesday, as you. Again? Tuesday. Next Tuesday.
Again. Item number 14. May I please alert, sir? The petitioner
2017 matter. Yes, Mr. Vishwa.
The petitioner has filed this writ petition challenging the advertisement made for appointment of Asha, my lord, in the village Jinkpoda under Bhaktipoda block, my lord. The petitioner was selected.
You are challenging the
advertisement, fresh advertisement.
So an interim order was passed.
Yes, ma'am.
What was the interim order?
Because, my lord, in 2014, the petitioner.
No further action shall be taken pursuant to that advertisement.
Well, because 2014, the petitioner was selected.
Yeah, let us come to the facts now.
My lord.
Yes.
Yes. Your lordship may see Annexure 1, the qualification of the petitioner. The petitioner has passed health worker female having higher qualification, and advertisement has been made and in the Annexure 2, page 20. 30/12/2014, my lord. There the criteria has been fixed. प्रार्थी निश्चित भाव जड़े महिला विवाहित होइतिबे और आशा पई आवेदन करथुवा ग्रामर बासिंदा हेबा वांछनीय। बयस 25 रु 45 वर्ष मध्य होइतिबो प्रार्थी सर्वनिम्न सप्तम पास करते ओडिया पडिया other aspects are there. But it is for प्रार्थी ठारू झिंकीपदा गां पई आशा चयन निमंते दरखास्त आह्वान करा जाउछि। Thereafter the petitioner was selected, but no appointment order has been issued. And again, another, because another advertisement was issued on 3/1/2015, stating that.
No, Mr. Vishwa, you say that pursuant to this advertisement, there was a selection and you were selected.
Yes, ma'am.
Where is the document to that effect?
They have admitted it in the counter. Nothing has been supplied to.
All right.
Thereafter, another advertisement has been published on 3/1/2015, because at that point of time.
That is, I think, 15/12/2015.
3/1/2015 now, Tarikh Omar.
15/12. Page 22 though?
Yes, my lord, page 22. Sorry. That again advertisement has been made for the same successful from village.
Which has been stayed?
No. In that case, selection also the petitioner was selected. Okay. But no appointment order has been issued. And because this advertisement has been given because there is a criteria that she should be past 10th. For that reason, new advertisement has been made. They have stated in their counter affidavit. And in that, the petitioner was selected, but no appointment has been given. Thereafter, an advertisement has been published on Annexure 5, page 25 in the year 2017. Yes, my lord. They have stated the Garo Eco number word point. That is also dears of the guideline, my lord. Guideline doesn't say for every word that should be an Asha Karmi. For the village. For every 10,000 population, there must be a Asha Karmi. For that reason, in a village, that should be.
If the village has more, let us say 20,000 population.
Yes. It is specifically. Again, one कर देले कारण मते देबेनी मु वार्ड 2 रो जेतु बासिंदा मते न दबा पे एटा बाहर करले for that reason I challenge that and your lordship has interfered and granted entry order मारे counter affidavit has been filed by the opposite party number 3 and 5
3 and 5 की state मारे
there they have stated that the petitioner was selected and the advertisement was cancelled on 23/2017, my lord. Advertisement was made in 2015, where I was selected, and they have cancelled it 23/2017, and the fresh advertisement has been made for the first time. They have stated in the counter affidavit. What is the reason? And they have stated that the committee has objected the appointment of the petitioner after 2 years, my lord.
Yes.
In the counter affidavit, page 9, my lord. Probably running page 42, my lord.
C/5.
C/5, my lord. And there they have admitted that I was selected.
Yes.
And now in the fresh advertisement, the opposite party number 6 has been selected, my lord, who has been added because he has filed an intervention. He has been added as the party also.
Yes, let us hear the state first.
But admittedly, my lord, the first advertisement which was issued, my lord, that it says, my lord, इच्छुक प्रार्थीଙ୍କ ଠାରୁ ଝିଙ୍କି ପଦା ପାଇଁ କରାହଉଛି. Then the revised advertisement was also issued. There also it was indicated as ঝিঙ্কি পদা. But at the time of selecting the candidates, my lord, the selection committee found, and after the objections were raised by the villagers.
Why don't you come to page 42 straight away?
Yes, my lord.
You're running page 42, which is annexed to C/5.
Yes, my lord.
Which is just being placed by Mr. Biswal. Whether this is in conformity with the guidelines or not.
My lord, the guideline is of 2016, my lord, which was in force as on that date, my lord.
2016.
So the revised guideline was 2016.
No, but what about the guidelines existing in 2015?
Well,
when the first two advertisements were issued. One was in 2014, one was in 2015.
My lord, the revised, but the guideline says, my lord, that it is the education qualification is for the 10th, but in case a 10th past candidate is not available, then also, my lord, a candidate having the qualification of 7th also she is also eligible. My lord, that is not the ground, my lord. The ground is that, my lord, with respect to Zinkipada village, actually, my lord, taking into consideration the number of population, one person is already available working as Asha. And that particular person belongs to ward number 2. So, my lord, they wanted to confine this particular selection for ward number 1. Since that particular condition of ward number 1 was not indicated in the previous advertisement, and the selection could not be finalized, the selection process could not be finalized in that way. So, for the selection of the present petitioner, my lord, that is only a proposal. That was not finalized.
How can you say that?
Because, my lord, that selection committee could not finally recommend anybody.
No. But that we will go to. But the second advertisement was issued in December 2015.
Yes, in that December 2015 selection process, my lord, there also, my lord, there was no indication with respect to ward number 1.
So you have to stick to it. And what was the guideline?
My lord, the guideline.
We have to look at the extant guidelines.
Yes.
The relevant guidelines.
Well, I am sorry, I have just set it 10,000. It is 1,000.
1,000.
Yes, ma'am.
Sorry. It is, may I
taking into consideration the number of persons, my lord, that is.
That's all right. That's all right. But what was the guideline in 2015? You cannot go on changing the criteria.
Till that, this is the guideline. You have changed the guideline for urban area, not for rural area. Download website available guideline.
No, he has to clarify. He has to clarify.
We have not.
Please hear me. First is, in December 2015, you issue an advertisement without specifying the wards.
Yes.
Rightly, wrongly, whatever it is your decision. So that must be in conformity with the guidelines then existing.
Yes, ma'am. It is first one is in 2014.
2014, yes.
That was first one is in 2014. That was cancelled on the ground that, my lord, minimum education qualification. Now the second one is on 15/12/2015.
And admittedly, she has the minimum qualification.
Yes.
She has the qualification.
Yes.
She was selected.
Proposed to be selected. Well, merit list has been drawn, my lord.
That is selected,
But-
not appointed. Selected but not appointed.
It was only proposed, my lord, it has.
Let us come to your counter then, what are you
Yes,
stated
that is what my lord
specifically?
stated. Since there was a complaint and it could not be finalized, that is why, my lord, it was.
Let us see.
Yes, ma'am.
A by 5.
10, man. I'm just referring to that. Yes.
Yes.
My lord, with respect to.
No, I think we can come to paragraph.
My lord, page number, internal page 2, my lord.
Yes,
My-
that is what I'm saying. Second paragraph, please.
Second, the advertisement dated 30th December 2014 was cancelled due to mistake in education qualification in Asha. Thereafter, my lord, the revised notification was issued. And taking into consideration the guideline which was in force on 27/9/2012, that is only with respect to that education qualification. That not the entire one. Then again, the advertisement is issued on 15/12/2015 according to the education qualification as class 10th. The selection was made by the selection committee at village level and prepared the provisional merit list pursuant to the advertisement dated 15/12/2015 as follows. The name of the petitioner, my lord, Dukhini Behra, second, ANM passed and proposed for selection. Then, my lord, on scrutiny, it was found that the petitioner belongs to ward number 2, Jinkipada village, where the Asha is already appointed. The villagers present at the time of selection also raised objection for selection of the petitioner as he belongs to ward number 2 of that village and advised to select the candidate who belongs to ward number 1. The selection committee could not finalize the above selection and advised to make fresh advertisement only for the candidate belonging to ward number 1, Jinkipada village.
But Mr. Patnaik, if there is already an Asha for ward number 2, why was the advertisement issued? An advertisement specified which ward?
Which one? That is admitted, my lord, in the previous 2 advertisements.
So instead of cancelling, they could have also issued a corrigendum, limiting it to ward number 1 or 2, whatever.
Ward number 1. Ward number 1. Well, in that case, my lord, the candidature of the petitioner is not going to be served.
See, what is the law? Being merely included in this election or select list does not confer any vested right. Though it will give rise to the legitimate expectation. Cancellation of advertisement by the authorities or cancellation of appointment selection is permissible.
Yes.
But it cannot be arbitrary. It has to be backed by reasons.
This is the reason, my lord, what we have indicated.
That has to be examined by the court. So for that, we have to see the 2012 guidelines.
Yes, ma'am. I will produce.
Where is the guideline? The 27/9/2012.
This is the guideline as per my.
Data nahi hum kahin use karenge.
No, 27/9/2012, my lord, we have given that.
Where is that?
That is only with respect to qualification, and it's A by 5, my lord. So that is only with respect to the 10th qualification. But prior to that,
Then come to 22/8/2012. As suggested by Minister of Health, the Government of India, 10th standard will be taken as desirable educational qualification.
yes, ma'am.
This criteria will be applicable only where new Ashas are to be selected. Is rated selection should be. No, it's not very clear.
No, it is only with respect to the qualification, madam. This was not taken into consideration at the time of first
So this guideline, which was issued subsequently in the year 2016, is a revised guideline.
That is a revised guideline. And thereafter 21, thereafter 22.
So I would like to know what was the guideline existing as on the date of second advertisement.
I will put this.
All right. After hearing, then comes from the parties. This court would like to know as to what were the guidelines prevailing at the time of advertisement dated. At the time of, at the time of publication of the advertisement on 2015. Direct State Council shall apprise the court accordingly and produce a copy of the guidelines For perusal of the court. Place this matter on. When do you want? When can you produce it?
10 days time maybe.
Next?
10 days time may be given. I'll
2nd July.
Yeah? 2nd July.
Yes.
Interim order, ma'am.
Interim order to continue.
Item number 15.
Huh? Yes.
My lords, petitioner was working as a GRS. My lords, he was disengaged as he remained in custody more than 48 hours. My lords, after acquittal,
He is working as what?
GRS,
Yes.
Gramo Rojgar Sevak. My lords, after acquittal, he claimed his reinstatement. As his claim was not responded, he approached this honorable court. My lords, a similar judgment has been given by your lordships that death chart. That in that case, Anganwadi worker was involved in a criminal case and disengaged due to remaining in the custody. After acquittal, my lords directed for reinstatement. A covered matter, my lord. My lords, exactly sir.
There is no covered matter in this court.
My lord.
Each matter stands on its own legs.
My lord.
I may refer to this.
My lord.
Covered matter. No.
Similar situation.
Just. Yes, Mr. Patnaik.
Yes, sir.
So an order of disengagement is issued.
Yes,
My
yeah,
lord.
he has been disengaged.
Annexure 1, my lord. Page 10.
किसी रखा जाऊंगा ये. On account of registration of case number against the accused Madhusudan Sahu, Gramo Rojgar Sevak. Then what happened?
My lords, judgment of acquittal annexure 2, page 11.
Yes.
After acquittal, my lords, he represented for his reinstatement.
What do you say?
We have not filed any counter matter in this case.
Counter is not necessary. Counter will not be necessary. Because these are all admitted facts. He was taken to custody. He remained in custody for more than 48 hours. And on that basis alone, he was disengaged without giving him any opportunity of hearing and without considering this fact of his acquittal in the very criminal case.
No, he was disengaged first. Later on, in the year 2019, later on, he has been acquitted.
Only because of his involvement. He was never convicted at that time.
No. He was detained in judicial custody and he was involved in that particular criminal case. And the criminal case was also ended with an acquittal because the informant did not want to proceed with that case. So there are repentations, my lord, which are pending according to him, my lord, before the collector. And taking into consideration the decision of
the judgment. The judgment is very clear.
Yes. So there may be a direction.
This is of the year 2021.
Yes, ma'am.
In that case, there, since there has been a development in the meantime, and that development has not been taken note of, I think it's better if the authorities consider. Yes. Question.
Sir, if the matter will be left to the authorities, it will linger. Respond colony will
Yes, Mr. Patnaik, we'll allow the application.
or GRS matter.
We'll allow it. What do you say?
When I do not know, my lord, whether that particular post has already been filled up or not.
There are, my lords, there are several posts vacant in the district, my lords. GRS post have been vacant and miscase to that extent has been filed. My lords, my miscase is
So has an interim order in the past?
no, my lord.
No, my lord.
Now tell him. There was an advertisement.
1/20/2023.
No, there was an advertisement was issued. I would like to know. No. Since an advertisement has been issued, if you want a clean order,
advertisement a post paino. Se district re ki throughout district se advertisement bahar kela. Ebe bhi post
we do not know. Let them come up with that instruction. I can allow you writ application. I'll be willing to do that. But provided I know the current staff position. Isn't it?
That observation, my lord, there may be a direction also to the authority to consider his case.
Yes, that will be better actually. I will direct them because I will also permit you to submit this
my lord.
judgment. So that will be easier.
Yes,
I will frame a specific, I'll fix a specific time limit. That will better.
My lord.
The petitioner has approached this court seeking the following relief. The facts of the case are that was there an advertisement when engaged?
My lord.
That
I have been engaged.
Pursuant to an advertisement. The petitioner submitted his candidature for being appointed as Gram Rojgar Sevak. Who district?
Bhadrak district.
In Bhadrak district. Stop.
In Arua
Gram Panchayat.
Arua Gram Panchayat in Bhadrak district. As per engagement letter number 209 dated 16/1/2008, the petitioner was engaged as such. Was engaged as Gram Rojgar Sevak bracketed GRS का मूल रखी थी है ना? And he joined as such on 22/1/2008 by executing an agreement with the sarpanch of the said GP. Subsequently, on 31/10/2019, he was transferred and tagged to the office of Basudepur block under DRDO Bhadrak. On 6/1/2019, on the basis of an FIR lodged by the additional program officer of Basudepur block, Basudepur PS case number 348/2019 was registered against the petitioner for alleged commission of offences under section 341/354 IPC. He was arrested and forwarded to jail custody on the next day. The project director DRDA Bhadrak, purportedly acting on the order of the collector cum CEO Jilla Parishad, issued an order dated 13/11/2019 disengaging the petitioner as Gram Rozgar Sevak because of his custody for more than 48 hours and his criminal involvement in the criminal case. It is stated that the order of disengagement was not preceded by any show cause notice whatsoever. The criminal case being GR case number 622 of 2019 ended in acquittal of the petitioner as per judgment passed by the JMFC Basudapur on 22/3/2021, wherein the prosecution was found to have failed in proving his guilt. The petitioner thereafter submitted series of representations addressed to different authorities. Stop there being no response, he has approached this court in the present date application, seeking the relief as already stated herein before. Heard Sri A. You are Mr. Aparas Bhoi.
My lord.
Heard Sri Aparas Bhoi, learned counsel for the petitioner, and Sri Asan Patnaik, learned AGA for the state. Sri Bhoi would submit that the order of disengagement is bad in law, not being preceded with the show cause notice, which amounts to which is a violation of the principles of natural justice. He further submits, even otherwise, the petitioner has been fully acquitted from the criminal charge. That apart, as per the settled position of law, mere involvement in a criminal case without being held guilty cannot be a ground to disengage a person. Sri Asan Patnaik, learned AG, on the other hand, would contend that the order of a disengagement, that the petitioner was not holding a civil post under the state, for which the procedure required to be followed for removal / disengagement of government servants is not required to be followed in his case, was not required to be followed in his case. As per the terms of his agreement, shall we could लिखा है? No. Look on this. Further, the judgment of acquittal was passed subsequent to the issuance of the order of disengagement, and therefore can have no bearing on the same. Sri Patnaik alternatively contends that the petitioner has already approached the concerned authorities after passing of the judgment of acquittal, but no action has been taken so far. And therefore, continue, and therefore, therefore he should wait for a decision to be taken on his representations. Stop, para. अच्छा सीरीज जो पिटिशनर जो भी कले ने हैं पिटिशनर को सबमिशन लास्ट लिख श्री भोई फर्दर रेफर्स टू has further Shri Bhoi relies upon a judgment passed by this court on 23/8/2022 in the case of Minoti Mahalik alias Naik versus State of Odisha and others, bracketed WPC number 11258 of 2020. Wherein this court, taking note of a similar situation arising in case of an Anganwadi worker, had disapproved the action taken by the authorities to disengage her from service, disengage her from her post. After hearing learned counsel for the parties at length and on perusal of the materials on record, this court finds force in the submission of learned state counsel that the fact of acquittal of the petitioner from the criminal case was obviously was subsequent to when there was a subsequent development, as the order of disengagement had been passed much before, that is on 13/11/2019. This court further finds that after passing of the judgment of acquittal in the criminal case, the petitioner has approached the concerned authorities, namely the collector Bhadrak, PDDRDA Bhadrak, and BDO Vasudevpur by submitting several representations, copies of which have been enclosed to the writ application. No action has been taken. No action appears to have been taken on such representations till date. Obviously, it is for the concerned authorities to take a decision considering the facts of the case and the developments and the subsequent developments. Stop. In such view of the matter, this court deems it proper to dispose of the writ application, granting liberty to the petitioner to submit a fresh representation addressed to the collector Bhadrak within 2 weeks from today, highlighting his grievances and enclosing copies of the judgment of acquittal passed in the criminal case. Stop. It shall also be open to the petitioner to cite the judgment of this court referred to earlier and any other judgment that he may so desire. If such representation is submitted within the time stipulated, comma, the collector Bhadrak shall do well to consider the same, to consider and dispose of the same in accordance with law, after taking due note of the petitioner's acquittal from the criminal case, comma, the settled position of law, and after granting him an opportunity of hearing. Stop. A decision in this regard shall be taken by the collector within a period of 6 weeks from the date of filing of the representation. Yes.
And not 16.
16 final mediation report. Report has come. Unsuccessful. Aye. Dear Lord, the mediation report dated 17/5/2024 indicates that the dispute between the parties could not be settled. The transfer application is therefore taken up for hearing on its merits. Yes.
On merit, I am not ready.
Merit, no, I am for the wife. You want to transfer?
Yes. One divorce application is pending for the learned judge family court at Bhubaneswar. And restitution of conjugal rights petition has been filed before the learned judge family court at Baripada. So I seek the section 9 petition from Baripada to Bhubaneswar.
Yes, what you want?
Well, next one. I'm not ready on merit.
Yes, sir.
I'm not ready on merit. Pray for next week.
All right. Let's just matter next week as prayed for by Learned Counsel for the opposite party. Is there any interim order?
Yes.
Interim order to continue.
I do not.
Next, get ready next week.
Next Tuesday. Next Tuesday.
Next week, next Tuesday की कोर्ट से करियो.
Please, Lords. Discuss the present petition of the mother-in-law.
Item 17 years.
17. Old lady of 60 years. Moved before this Hon'Ble court, they were praying to.
Run. Okay, go to. Notice on the opposite party. No appearance from the opposite party. Learned Counsel for the petitioner is present. There is no appearance from the side of the opposite party. The order sheet reveals that notice having been served, the opposite party was granted opportunity twice to appear and contest the application. But he has chosen not to. Stop. I therefore find no reason to keep the transfer application pending. Yes.
My lord.
Yes, the wife.
I am the mother-in-law, my lord. Dispute with regard to the LIC policy, my lord. In the opposite party being the plaintiff filed a suit for equal share in the LIC policy, my lord. That is at that is under Annexure 1 at page 8, my lord.
You want the case to be transferred from which
Sambalpur to Titlagarh, my lord. That is near about 200 kilometers away. The present petition is a old lady. She is the mother-in-law. She is the nominee, and she is residing there at Titlagarh, my lord. And there is, I have also stated under para 7 that daughter-in-law after the death of the son, she is also threatening with regard to, she is not participating in the proceeding. Under para 7, my
This is an application for transfer of CS number 141 of 2020, pending in the court of Learned Civil Judge Senior Division Sambalpur to the court of Learned Civil Judge Senior Division Titlagarh. Said suit has been instituted by the present opposite party, claiming share in the claiming share in the LIC policies. Purchased by late Bholenath Suna. The petitioner is the mother of late Bholenath Suna and a nominee in 4 LIC policies purchased by him. After his death, the opposite party, being his widow, filed the aforementioned suit, claiming exclusive share over the maturity value of the death benefit policies, death benefit amount under the said policies. Therefore, transfer of the suit has been made on the ground that the petitioner is a resident of Sambalpur. So you wanted to be transferred to Titlagarh. You wanted to be transferred to Titlagarh. Yes. So you are a resident of Titlagarh, and being an elderly lady without any support finds it difficult to travel to Sambalpur. Stop. On the other hand, it is submitted that the petitioner, that the opposite party has been appointed in a job in the railways.
Yes, ma'am.
Under the rehabilitation assistance scheme after death of her husband, but has not been maintaining the petitioner or taking any care of her. As already stated, despite repeated opportunities, the opposite party has not appeared to contest this application. Stop. As such, the adjournments made in the transfer application have gone unchallenged. Apart from the doctrine of non-traverse, this court, after on a comparative assessment of the age, economic and social position of the petitioner and the opposite party, finds that it would be more difficult for the petitioner
to travel from Titlagot to Sambalpur than for the opposite party to travel from Sambalpur to Titlagot. The comparative inconvenience appears to be more for the petitioner than the opposite party. Under such moreover, facilities for the opposite party can always appear through virtual mode whenever necessary. Under the above circumstances, I am inclined to allow the play for transfer. Stop. No, the transfer application is therefore allowed. Stop. It is directed that the proceedings in so and so pending in the court of such and such shall be transferred to such and such court. No. The parties are directed to act upon receipt of notice issued by the transferee court upon receipt of records. Hello. It shall be open to the opposite party to seek permission of the court to appear through virtual mode if she so desires. Further, the personal attendance of the parties shall not be insisted upon by the court unless absolutely necessary. Yes. Hari. आपको तरह होगा बिल्कुल लग रहा है नहीं मॉडिफिकेशन होगा मॉडिफिकेशन अपडेट होगा मतलब 5 मिनट भीतर आसुची है ना এটা মত
The innocent petitioner. Last date, my lord asked for the charge sheet, which has already been received. Kindly. It is perhaps with the file now. My lord, the petitioner though staying here at Cuttack. So for the commencement of the trial at Raigada,
somebody had appeared for the opposite, or you are appearing?
My lord, state.
Okay. Yes, yes, please.
Appeared. Thing is that though I am staying here at Cuttack and Raigada, there are so many enemy like I cannot place an advocate there because the advocate of Raigada they are also against me. So I'm afraid to go there. I'm here. I'm ready to pay every to and fair for every person. And if it's possible, any adjacent area like Gunpur or Baharampur, anywhere, I can bear all expenses. To
Why?
Go there, I'm political. It's a political, and here so many more than 190 persons are given him equal in that school. So I'm afraid to go there. I cannot engage any lawyer. It's a political issue somehow. So first of all, a complaint given to the collector. The collector he reported to the police station, and in that way the FIR been registered.
100%.
More than 100% something. So
advocates and political men
persons are there.
Sign in the report, my lord. This is very dangerous.
So I'm afraid it's dangerous for my life also.
Any other place in nearest, my lord?
All 100 complaint informants are not going to appear as witnesses. I wanted to see the charge sheet to know the number of witnesses. 33 witnesses. You leave aside the official witnesses. Official witnesses are 1, 2, 3, 4. 4 official witnesses are there. Doctor की जो थी वो ये मानो छाड़ी दले बाकी समस्त करो बाकी हेलेनी
29.
ପ୍ରାୟ ବାହାରିକି ସବୁ ବାହାରକୁ ମାନେ
All 29 witnesses will come to another place. That is the problem. But you can be granted protection by filing appropriate application before the court. This court can grant you that liberty, number one. Number two, you can also appear through virtual mode. You need not appear personally every day. Accused persons can appear virtually.
My respectful submission, my lord, ସେ ଯୋଉ ମାନେ ଅଛନ୍ତି witness, they are also married to other place. ଏଟା nearest ହଉଛି ରାୟଗଡା ଯେତିକି ବାଟ ହବ ଗୁଣପୁର ସେତିକି ବାଟ।
ସେମିତି କରିହବ, ସେମିତି କଣ ଖୋଜିବ? ଇଣ୍ଡିଭିଜୁଆଲ ୱିଟନେସ୍ ମାନେ କୋଉ କୋଉ ଜାଗାରେ ଅଛନ୍ତି ଆମେ ଖୋଜିକି କଣ ଗୋଟେ ଜାଗାରେ କରିପାରିବୁ? ସେମିତି ହବ।
ଆଡ୍ରେସ ଦେଇଛନ୍ତି
ଯୋଉ ଜାଗାରେ ହେଇଛି ସେଇ ଜାଗାରେ
witness ସବୁ transfer once in and retired.
The court will look at 2-3 things. First is your protection. Second is your legal representation. You say that you may not get a advocate. You can take any advocate. Third thing is that you can appear virtually. All these things will be permitted by the court.
respectful submission running base 23 my lord, ସେ local advertisement ବି sign କରିଛନ୍ତି ଏଥିରେ ସବୁ।
କରନ୍ତୁ।
ତେଣୁ ସବସିଡିନାଲ ଜଷ୍ଟିସ ଆଉ ପାର୍ଟି ପାଇବନି।
ଆପଣ ଜାଣନ୍ତି କରିବେ, ଆପଣ ଜାଣନ୍ତି ଭଲ ହବ କଣ? ମୋର ତ ମେରିୟର ବହୁତ ମିଷ୍ଟର ଷଡ଼ଙ୍ଗୀ ବାଟ ସେଇ ରାୟଗଡ଼ା ଯାଇ କେସ୍ କରିବ କଣ କରୁନାହାନ୍ତି? ଆମର ଏଠି ତ ବହୁତ ଲୋକ ଯାଉଛନ୍ତି ବାହାରେ ସେସନ୍ସ କେସ୍ କରିବା ପାଇଁ।
ତାର ଗୁଣପୁର ହଉଛି ଅଲରେଡି 50-45 କିଲୋମିଟର, ତାର ବରହମପୁର ଇଜ ବେଟର।
ଏଟା ଆପ୍ଲାଇ ପୂର୍ବଟା ଆଲାଉ କଲି, ଏଟାକୁ ଆଲାଉ କରୁନି କରିବା କଣ ଅସୁବିଧା ଅଛି? କାହିଁ ଆଲାଉ କରୁନି?
ପ୍ରିନ୍ସିପାଲ ପୋଷ୍ଟ ନାଉ ଡିସମିସ୍ ଫ୍ରମ୍ ଜବ୍। ଆଉ ସେଠି କିଛି ଆଉ ଜଷ୍ଟିସ ମିଳିବନି।
Justice is definitely no. You cannot question the impartiality of the judicial system. Our officers are there. They are very fair and.
Minor can see running by 23 million.
I will. I remember now. Last time we had made elaborate submissions. 23 yes. Oh, see. Charge sheet देखिए लेंगे। 60 जन दीजिए ऊपर सप्लीमेंट दीजिए 29 जन। 60 plus 29 ହେଲେ ପ୍ରାୟ 89-90%
ସାକ୍ଷୀ ନାହାନ୍ତି, but they are signed in FIR। FIR ଦେଲେ କଲେକ୍ଟରଙ୍କୁ, କଲେକ୍ଟର 2 ବର୍ଷ ପରେ ପଠେଇଲେ। ସେ ବି କଲେକ୍ଟର ପଠଉନଥିଲେ, ପଲିଟିକାଲ ପ୍ରେସର ହେଲା, ଆଡଭୋକେଟ ଆଉ ସେଠିକାର ଲୋକାଲ ମ୍ୟାନ ଯାଇ ପ୍ରୋଟେଷ୍ଟ କଲେ, ଏଇଟା ପଠାନ୍ତୁ। ସିଏ ଓପି ନମ୍ବର 2 କୁ ପଠେଇଲେ 2 years। ଆଉ ଯୋଉମାନେ 164 ଦେଇଛନ୍ତି ସେମାନେ ଡେଟ୍ ଅଫ୍ ଅକରେନ୍ସ 2 ବର୍ଷ 6 ମାସ।
ସେଟା ତ ମେରିଟ ଆପଣଙ୍କ ଡିଫେନ୍ସ
ଫର ଜଷ୍ଟିସ ପିଟିସନର ଏଇ ଯେ ଡକ୍ଟରେଟ
been made and thereafter
whatever.
Yes, ma'am.
So they are all our political men.
No, this will not be transferred. I will give you this liberty, 3 liberties. First is you will seek protection. If at all you are required to appear physically, you are not required to appear physically always. Only at the time of pronouncement of judgment, and that too if their judgment is is a conviction judgment, then only you are required to appear. Even these days, accused statement is being done through virtual mode.
Yes.
That opportunity will be granted unless it is absolutely necessary. In a criminal case, sometimes it becomes necessary for the accused to appear. You will be granted protection. Third thing is that, if a lawyer is required to be engaged, any lawyer that the court will look into it.
Virtual mode instruction नबो petition next week आसु virtual mode करियो कि ना करियो।
ଆପଣ ନିଅନ୍ତୁ, ଟାଇମ୍ ତ ମନା ନାହିଁ, କିନ୍ତୁ virtual mode କରିପାରିବେ। ମୁଁ ନିଜେ କରିଛି, I have done it. Before coming here, I have done it.
Next week.
As requested, as prayed for by counsel of the petitioner, is this matter next week.
Intermediate counsel.
Intermediate to continue.
Item number 19.
I think that would lecture kon aschi extension thing. Four months further time is granted to the court below to dispose of the case as directed. Yes.
Item number 20.
May I please your worship?
Yes.
Petitioner saw interim bail, my lord. Already he has surrendered to custody on 6/4/24, my lord.
Yes. Now what?
Now
I think surrender certificate
certificate
filed, my lord.
file करछि.
File କରିଛନ୍ତି? File କରିଛନ୍ତି?
Out of 18 witness, only 5 witness have been examined, my lord. 2 years, 8 months, my lord. More than 2 years, trial has not concluded.
You filed another IA?
My lord?
ଆଉ ଗୋଟେ IA file କରିଛନ୍ତି?
ନା.
ନାଇଁ
IA file ନ କଲେ କେମିତି ଅଟୋ ଦो? This is a dispute of matter.
Peaceful.
ସେମିତି ହବ? fresh bail application file କରୁନାହାନ୍ତି ଆପଣ ସେଥିରେ ଫାଇଲ କରିଥିଲେ ତାକୁ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଦିଆଗଲା ଆପଣଙ୍କ ଏକ୍ସଟେନସନ ହେଲା ଆପଣ ସରେଣ୍ଡର କଲେ ମ୍ୟାଟର ସେଠି ଏଣ୍ଡ ହେଇଗଲା
revoke କରି
ହଁ
better revoke କରି
ଆଜ୍ଞା ଆଜ୍ଞା ଶୁଭିଲାନି
withdraw କରୁଛି
ୱିଡ୍ର କାହିଁ କରିବେ ୱିଡ୍ର କିଛି ଆପଣ ଫାଇଲ କରିନାହାନ୍ତି ୱିଡ୍ର କଣ କରିବେ you file another application regular bail application you file that will be considered and what can be passed yes what you say Mr. Mishra
I file for
ହେଲା ଖାଲି counsel for the petitioner no sir ଛାଡ them list this matter list when moved no list of moved dispose of ହେଇଯାଇଛି ପୁରା
19 ଚାଲି dispose
this has been disposed of on 19/10 ନା ନା ତା ପୂର୍ବରୁ ହେଇଛି 19/7 19/5 I disposed of ହେଇଛି the bail application disposed of bail application was disposed of on 9/11/2023 since this is a disposed of matter and the petitioner has already has already filed the surrender certificate, no further order needs to be passed. In this case, yes. So you, in the meantime, you file your application.
Item 21. Lordship
Lordship, in this matter.
No order needs to be passed. Yes.
My lord, in this matter, I'm through virtual mode. My lord, my application is listed for the hearing on my regular bail. Honorable Supreme Court has requested, my lords, to dispose my prayer. My lord, I have been in jail for almost 3 years. I was on interim bail for 4 months. Lordship, in this 4 months, I appeared on each and every date in the trial court. Lordship, not even a single witness has been examined. I have surrendered on time. There is no allegation qua me that I have breached any of the terms and conditions imposed by the learned trial court. Further, there is no antecedent regarding me of
Your
any
application has not been obtained.
All right, then we'll hear the main bail application.
Yes, Lordship. Yes, Lordship.
I'm fixing a date. Let him obtain the case diary. We'll finalize.
Yes.
Short
Yes,
date.
my lord. Short date, Lordship.
The learned additional session judge cum special judge Koraput has informed that only 1 out of 14 charge sheet witnesses have been examined so far. Stop. Sri Sham Manohar, learned counsel of the petitioner, requests that the bail application be taken up for hearing on merits. Stop. Then State Counsel is directed to produce the case diary. Place this matter. Kebe, when can you, when early?
After?
On 2nd July.
Yes, my lord.
This matter on 2nd July.
I'm obliged, Lord.
Yes. 22. During building report as flag K, copy of earlier stage, no? Flag K, what is the report? Flag K. Status report. Out of 70, 7 witnesses have been examined. Learned District and Session Judge Bhadrak has informed that only 7 out of 70 CS witnesses have been examined so far. And another witness has been examined in part. Yes. What is this matter?
Here, my lord, petition is languishing in the jail custody. A lady male languishing in the jail custody on 28/3/2022. More than 2 years and 3 months, my lord. The petitioner has not named in the FIR. So, main, my lord, allegation against Sir Mr. Raut, who is the owner of Sampurna News, my lord. The deceased is the cameraman who has kept some video clips of Sir Mr. Raut. That's why, my lord,
I have considered your application and rejected it on merits.
On merits.
So,
and
Eyewitness has been examined. So, like,
and on the basis of the allegation against one, my lord, one, Sarojini Sethamal. He has,
Yes, he has
in the
already been examined.
he has been examined. I paid for interview because out of 70 only 7 witnesses have been examined. And I have been custody more than 2 years and 3 months.
Yes.
And only for interim bail, my lord.
The petitioner's earlier application for bail was rejected on merits by this court. As per order passed in DLAPL number 11158 of 2022. The present application has been filed as the trial is progressing slowly and the petitioner has in the meantime spent nearly 3 years in custody by now.
More than 2 years and 3 months.
Spent 2 years, 3 months in custody by now. This court finds from the status report submitted by the trial court that as many as 70 witnesses are to be examined, of whom only 7 have been examined so far. So, there is therefore force in the submission of learned counsel for the petitioner that trial is in fact progressing slowly. In the circumstances, taking a lenient view, and particularly the fact that the petitioner is a lady, the bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 1 month. Yes.
2 months.
बिल्कुल हवा का था नहीं.
Trial is going on. She shall not influence the.
On such terms and conditions, sir, she shall appear personally before the trial court in each data posting of the case without seeking representation through counsel. Yes.
6 weeks. Item 23.
Extension of time.
First time?
Last time.
2 weeks.
Item number 24.
May I please, Your Lordship? Interim.
Yes.
Highly interim bail, my lord, instruction now.
Instruction was to be seeked on, my lord. It has come on 31/1/24. Instruction has not been.
January में शुरू instruction Friday भीतर instruction आना.
Yes, ma'am.
Friday
Legible copy of the medical.
Please, list this matter as requested by 11th State Council. List this matter on 21st June. Order the previous order be complied with positively. That's all.
Item 25.
That's okay. Be to show 20 paisa, my lord.
The regular bill.
My lord. 425 kg ganja. 25 kg. At the present, petitioner not present in the spot, but he was on remand. He was entangled in this case.
What is your name?
Kailash Chandra Jagdala.
You have the case diary?
My lord.
Yes. What does it show?
My lord. He has not been named, but from the investigation it reveals he is the owner of the vehicle, my lord. Notice was served to him. He didn't appear after NBW issued, and he has been arrested, my lord. And case diary also reveals that CDR from the CDR it is ascertained that he is involved by talking with the other accused persons, man. This is his role.
One.
And one CA is there, my lord. Similar nature.
That will take care. The petitioner is in custody since
29/10/2023 on remand.
29/3.
29/10/2023.
29/10/2023, having been remanded in connection with such and such case. The prosecution case is that huge quantity of contraband ganja, that is 425 kgs, was being transported in a Mahindra Maxi truck from Gundulia side to Baunsuni through Ambojhari, Khajuripada. Said vehicle was detained by the staff of both police station.
Two persons mainly.
Two persons were present in the vehicle along with the contraband ganja. Stop. On interrogation of the driver, Parameswar Karno came to light that they were transporting the ganja for commercial purposes. In course of investigation, the petitioner has not been named in the FIR. Stop. In course of investigation, it came to light that the petitioner is the owner, registered owner of the vehicle in question. On notice being issued by the investigating agency, the petitioner did not appear. The petitioner did not. Who?
Noticed.
During this case, a case for he was arrested in another NDPS case, and in between the notice was issued. Yes, ma'am.
21
the petitioner was then in custody in connection with another case. And since he failed to respond to notice of appearance issued by the investigating agency, he was taken on remand in the present case on the orders of the court. Stop. It is submitted that there is no evidence of the presence of the petitioner at the spot or of being in possession of the contraband, and that he has been entangled only because he happens to be the registered owner of the vehicle. Stop. The State Council has opposed the prayer for bail, thus submitting that there is evidence of the petitioner being in telephonic contact with the driver of the vehicle at the relevant time, which shows his involvement in the occurrence. Stop. That apart, he is a habitual offender.
Only one case.
Habitual habitual offender being involved in a similar case. Having heard learned counsel of the petitioner parties and on going through the materials available in the case diary, this court finds that, save and except for the fact that the petitioner is the registered owner of the vehicle, there is no clear-cut evidence to show that the contraband was being transported on his direction, or that he had any active role to play in it. Under such circumstances, I am inclined to take a lenient view. Let the petitioner be released, including he shall appear before the IAC of both model police station on every Sunday at 10 AM for a period of 6 months. Next, he shall appear before the court in session over the matter on each date of posting of the case, and no representation through lawyer shall be allowed. Yes.
Item number 26. Your Lordship was pleased to have this matter, my lord.
26.
Yes, my lord. Your Lordship was pleased to hear this matter, my lord, in the instance of the other co-accused persons, that other co-accused person I have annexed in page 14.
Dhanodas.
Dhanodas. And he has already released on bail, standing on the similar footing in comparison with this co-accused, my lord, 1, 2, 3. Here, my lord, allegation of the offence under section, my lord, 395. 450, 506.
Cash of 35,000 gold ornaments.
Nothing, and we are in custody, my lord, since 28/8/2023.
So
ଦେଇଛି ସବୁ।
they're on similar footing.
ସେ
Not
ସମସ୍ତେ
be-
ଘରେ ପଶିକି your lordship kind of a glance your lordship's order.
I've seen it, but he wants to go through the case diary.
No criminal जो ये no TI period nothing. And in the meantime charge
After
has
the
already
case
been framed sufficiently
No,
before.
no, Mr. Saul, let him obtain the case diary. Case diary देखी कर लो. Same order होगा.
ଆଜ୍ଞା ମୁଁ ମନା ନାହିଁ।
1 week.
Yes.
Yeah. Let's this matter on 2nd of July. The up-to-date case diary be obtained. Yes. Change ना होगा.
2nd July ଟିକେ ଅଧିକା ହେଇଯାଉଛି।
ବେଶୀ case diary ଆଣିପାରିବେନି ପୁଣି adjourn ହବ ଲାଭ କଣ?
ଚାର୍ଜ ହେଇକି ଆଜ୍ଞା ଟ୍ରାଏଲ ଚାଲେନି ଟ୍ରାଏଲ ଯଦି ସରିଯିବ ଲାଭ କିଛି ହବନି। ତେଣୁ ସେଇଥିପାଇଁ
Then next week करते. Next week.
Published orders.
Item 47.
You can also obtain instruction telephonically whether he stands on the same footing or not.
Next week, I will take.
If you as a regulation, State Council shall specifically obtain instruction whether the petitioner stands on the same footing as co-accused Dhanna Das, who has been granted bail by this court. Petitioners, whether the petitioners stand on the same footing as co-accused Dhanna Das, who has been granted bail by this court.
ଆଜ୍ଞା ଏବଂ criminal antecedent.
ଆଜ୍ଞା।
Item 47.
May I please, my lord. 40 kg, my lord, and the custody since 3/9/2023. And lordship also granted bail of one of the co-accused person while hold the vacation bench, my lord. Petitioner also similar footing. One Khogopati Harijan, he is also remain present at the scooty. And
The present prisoner pillion rider. Pachara.
Same order.
Yes, ma'am.
Same order.
He is a pillion rider. Pachara.
oblige.
Item 28.
May I please, your worship? May I pray for Passover after lunch? Item 28.
28.
It's my.
The petitioner is here. The petitioner is here. You are from whom?
I'm sorry, my lord. I'm mistaken. That is quickly. I'm sorry. Sorry.
Yes.
May I please, your lordship? This is an
Yes.
application of 438 of CRPC, your worship.
Yes.
Basing on an FIR lodged on 19th of August, the present petitioner has been implicated. 21st of August, my lordship. It is alleged that on 19th of August, the informant Abhishek Kumar Pandey was abducted from Damanjodi railway station by 5 unknown persons in a Bolero vehicle, and somehow, and from him 1,000 rupees was snatched, and a ransom was placed to his family members to pay some amount. Somehow he escaped and reported the matter. Police thereafter recovered the said Bolero, and after the Bolero was recovered, 4 accused persons were arrested, and all of them are enlarged on bail. One is enlarged on anticipatory bail by this honorable court in ABL APL 112.
Same order. Same order. All right, same order.
Oblige.
Item 29.
Lordship, on behalf of Amitabh Tripathi, on the last occasion, your lordship directed to state to call for CD.
CD last time did. Though informant has not appeared, that's why it has been adjourned.
No, the previous order is to specifically apply to the court whether the
307.
307 is met out.
Not made out.
Not met out.
Your lordship adjourned
Mr.
because
Sahu
that
was just here.
informant was
Mr.
not
DK Sahu was here. He, Mr. DK Sahu was here. Please inform him. After lunch, we'll take it up. Pass over. All right. He was just now he was making.
No information जा close है ये. Company को देखा सुना.
ना जहाँ भी हो तक नाटा अच्छी है तो से एक थिले तंको डाकी तो गोटा opportunity दे जाओ.
नहीं वो ना स्विम सही पद पे.
अरे will pass that order कौन gives? Yes. Pass over.
Item 30.
May it please, my lord. Lordship, the alleged offences are under section 363, 365, 323 and 34 of IPC. The victim, the wife of the victim lodged the written report that while he was roaming with his dog, 4 persons came in a car and took away the victim.
SJD was called for, but it was not.
Next week. Next week.
Positive.
After case there will be obtained. Let's just matter next week.
Lordship, may I prepare an interim protection?
No. Oh, interim protection.
Yes, ma'am.
All right, all right. No coercive action shall be taken against the petitioner till then.
Yes, my lord.
चला हैं वीकली स्टार हमको वो तो है ना कौन वीकली स्टोर है तो रख
Put list item number 1.
I am sorry, my lord, to intervene. There is a matter item 57 of port number 10 list.
সেটা যেটা আসলে কি যেটা সকালে মেনশন হয়েছিল
Special notice. 57 to mention.
No, 57 is indeed, I have not mentioned.
Yes.
So it is a matter of students. They have actually appeared examination of annual examination. So college has uploaded the internal marks and it was not actually added to the original mark, my lord, which is my lord, restrained the petitioner my lord, to apply for SAMS +3 degree examination. And during vacation, it was allowed, it was directed to the council my lord, to upload that mark, revised marks. And the state is directed to take instruction whether enhancement of the date can be possible or not. That was posted specifically today to take up.
It will come tomorrow. Justice Patnaik will be there tomorrow.
What's me say?
Item 57, release this matter tomorrow before the assignment. Yes.
Diplo.
Okay, ये कहते हैं छोड़ नवा vacation ये पर नवा launch पर नवा है ना launch पर नवा आधे से गोटे खाली पास ओवर रहला गोटे स्पेशल नोटिस रहला तो नोटिस फाइल टा नेक्स्ट हो कौन हां अब अदर साइड भी जिंती स्टेट भी जिंती कितना मैटर अछि रेडी हेले नि की एनीबॉडी अवेलेबल वीकली लिस्ट में था OPEC. Get the file, Mr. Das. Item 50.
Aye.
Special notice देखते. What is this matter, Mr. Pathak?
Matter is related to transfer. The petitioner has been Annexure 1 transfer. He has been transferred only 10 months left for his retirement. And there is no allegation against him, but all in sudden he has been transferred 150 kilometer.
Harivar Patel.
My lord. Serial number 7.
Sundargarh to Purnapani.
Sir.
But that is in the same district. Is it not?
Yes, yes.
It's in the same district, right? Not very far from Purnapani mines,
Sir,
I believe.
150 kilometers.
I say 150 kilometers है कौन है?
Sir, ଆଉ 7-10 ମାସ ଅଛି sir. ମୁଁ sir କେବିକେରେ 8 ବର୍ଷ 9 ବର୍ଷ ସବୁଆଡେ କାମ କରିକି ଆସିଲି sir. All over ମାନେ ଓଡ଼ିଶାରେ.
Who is opposite party number 4?
Opposite party number 4 next serial number 8. Sir, see actually sir see এই जो transfer new appointment the election new government for that reason perhaps he has been transferred. He is in office of the CDO Sundargarh.
The AFS Learned AG accepts notice
on behalf of opposite party numbers 1, 2, and 3. 3 extra copies of the writ application be served upon him by tomorrow. If you notice, the opposite party number 4 by speed post, fixing a short returnable date, the requisites for which shall be filed by tomorrow peremptorily. Is this matter? Is this matter before the assigned bench on the other week, 10 दिन पर date on 2nd July 2023. In the meantime, the petitioner shall not be relieved, if not already relieved, pursuant to order dated 11/6/2024, relieved from his post, from his present post. If not already relieved, pursuant to order dated such and such.
No, sir, aji 18th ଅଛି sir date.
Yes.
18th ଅଛି 18/6 to the କରିବା ପାଇଁ ଅଛି sir.
So?
If not
already released, so no, what do you want, Mr. Pati?
Not to give benefit because otherwise they will be, the order itself indicated that it will be joined within 7 days, that is on or before 18/6/2023.
We'll say that.
He can file an affidavit stating out what your lordship have ordered today.
Yeah. The order dated, in the meantime, the order dated 11/6/2024, passed by the Chief District Agriculture Officer Sundargarh, insofar as it relates to the petitioner Harihar Patel and the opposite party number 4, Anurag Sahu, shall not be given effective till the next date.
Urgent
certified copy be granted in course of the date. Maybe?
So item number 29.
Yes. Where is Mr. D.K. Sahu? He's not there. What do you want?
Indication of occupancies 294, 307, 4.
7 is not made out.
Not made out, my lord. Though informant has stated iron rod मारिया ପାଇଁ ଚେଷ୍ଟା କଲା ଘୁଞ୍ଚି ଯିବାରୁ ବାଜିଲାନି, but investigation reveals no allegation of 307 man.
Learned State Council has obtained instructions that the offence under section 307 IPC is not made out against the petitioner, as no injury was sustained. In such view of the matter, the petitioner is apprehending arrest in connection with such case. It is alleged that the dispute arose out of a breach of agreement.
Yes.
Between the petitioner and the informant, which led to lodging of the FIR. This court triumphantly finds that the dispute is basically civil in nature. No criminality can be definitely attributed in the act of the petitioner. In such view of the matter, while not being inclined to grant anticipatory bail, surrender release or bail. Heard Sri Sashikanta Tripathi, learned counsel for the petitioner, and Sri S.K. Mishra, learned ASC. None appears for the informant on repeated calls. Yes.
Item number 1.
Yes, item 1. Pass over.
Item number 2.
Item 2. The noting is the requisites for issue of limitation notice FS on respondent 527 not 5.
This order was passed way back in the year 2005.
My lord.
So I will not grant you any further time. I will dismiss the appeal.
No, appeal on sufficient age.
No.
So far as 5 to 7 is concerned, notice was issued to them.
You did not file the requisites.
No, requisite was filed. It came back. Because these people are, their address is Bihar. Present address was on Bihar.
What can be done?
How thare jiba boli diya haithala, afresh. Now what, and these respondents, they were set ex parte before the trial court and the appellate court, lower appellate court. Now, 5 to 7 may be
Deleted at your risk. Deleted at your risk. Yes.
and the matter will be taken up for orders in limitation.
Correct. Notice on limitation was directed to be issued afresh on respondent numbers 5 to 7 by order dated 21/3/2005. Such notice, the requisites for such issuance of such notice was not filed. The matter has been pending unnecessarily since then. In course of hearings, dismissal and counsel for the appellant, appellants submits that said respondents were set ex parte in the court below, and that he would not like to prosecute the appeal as against them. In such view of the matter, the appeal stands dismissed against respondent numbers
5 to 7.
5 to 7, or we'll delete them.
And by this.
In such view of the matter, the respondent numbers 5 to 7 are deleted at the risk of the appellant. List the appeal on next week, next week for hearing on the question of limitation.
Okay.
Beg your pardon, item 1, your lordship.
Item 1, all right. This is for admission.
Yes, your lordship.
Not been admitted.
Not admitted, your lordship.
Maintainability of the appeal.
Yes, your
Yes.
Yes, your lordship.
You are challenging the order of
The learned second additional civil senior district judge Athgad, your lordship. The present
matrimonial case.
Yes, your lordship. Factual background of this case is that the present respondent filed a civil proceeding which is ended in compromise before the learned judge family court Cuttack. He filed a section 25 proceeding before the judge family court Cuttack, and which has been transferred to the learned civil judge senior division Athgad for trial. And the learned civil judge senior division, in a wrong connotation, section 25 of Hindu Adoption and Maintenance Act petition has been filed, but he has taken it as a Hindu Marriage Act proceeding and allowed the proceeding in favor of the respondent. I prefer an appeal before this honorable court under section 19(1) of the Family Court Acts. And this honorable court in COVID time hold that this suit being tried by the learned civil judge senior division, the appeal would have been preferred before the learned additional district judge or available district judge. I prefer an appeal before the district judge and learned district judge. And learned district judge dismissed my appeal only on the ground of limitation. As against that, I prefer this appeal before this honorable court.
Act remains that it's a matrimonial.
It's a matrimonial. There is no dispute.
So the civil judge senior division was acting as the family court.
Family court.
Isn't it?
Yes, your lordship. The main crux is that 19(1) appeal which has been I have preferred before.
This may have observed.
May have
observed that appeal lies to the district judge. I will not pass any comment on that. Fact remains that it is a matrimonial appeal. So how a second appeal will lie before this court?
Only fact remains, your lordship. The appellant have no option. It is a section 100 application is there because it is general, and section 25 is not given. Hindu Adoption and Maintenance Act not provide any appeal. So 19(1) is the only section 19(1) of the family courts only govern for appeal, and I have preferred that.
What has happened in this case is, rightly or wrongly, you approached the court of district judge.
Yes, sir.
In my view, I may be wrong again, but my view is that application itself was not maintainable before the district judge. You could have straight away come to this court because the civil judge senior division was exercising power under section 19 of the
of the
Family
Court
Court
Act.
Act.
Yes, your Lordship.
Then RPFM?
Lordship, kindly visualize. Annexure 2 kindly have a visualize.
No, sir, that is why I asked you to find out.
Yes, your Lord. Annexure 2, you kindly have a glance. Annexure 2, I have preferred appeal. This honorable court. Page 19, your Lordship. Page 19.
I'll have to make a reference to this.
Yes,
This is
your
a
Lordship.
division bench order, so I cannot,
Yes,
I'll
sir.
have to make a reference.
Yes, your Lordship.
But so one thing, sir, support minute, there is a provision of appeal in the Hindu Marriage Act. That is, the appeal has to be referred as if a civil court decree. Since
True. But before whom?
before the civil judge senior division order before the district court, and thereafter second appeal before this court. The Family Court Act conducted the proceedings. That appeal under section 19, that is the appeal under matrimonial.
No, here what has happened is, here the fact is, the civil judge senior division Athawad, because there is no family judge in Athawad, so he is exercising the jurisdiction of Athawad.
Notification they have.
Notification, if it is maintainable, I will admit it.
That is maintainable in view of the appeal provision provided in the Hindu Marriage Act.
Hindu Marriage
Act.
Hindu Marriage Act.
केवल फैमिली कोर्ट जो प्रोसीडिंग टा करछन सेटा फैमिली कोर्ट एक्ट अनुसार प्रोसीडिंग टा करछन दी ता अगेंस्ट अपील सेक्शन 19 ता डिटेल
Appeal 28, your Lordship.
Pass on the book.
Yes.
No, on that day, probably I also told you, I have also, as district judge, I have also heard many appeals.
Yes, sir.
As Kevjar district judge, I have also heard and disposed of several appeals. But here there is a slightly different version. Section 28,
28, your Lordship.
All decrees made by the court in any proceeding under this act.
Seven.
फैमिली कोर्ट
Section.
I think this provision.
Yes, your Lord.
Still then I'll issue notice on the question of admission.
Admission. Only fact, your Lordship, kindly visualize the situations. Annexure 1, your Lordship. The order of the land and civil
On the
judge.
ground of limitation.
No, land and civil judge judgment to your Lordship.
Yes.
Annexure 1, your Lordship. First word, this an application under section 25 of Hindu Adoption and Maintenance Act 1956. Your Lordship, skip it out. Then he dealt to it under section 25 of Hindu Marriage Act. Page 14, your Lordship. These sections have been quoted. And the awarded.
Well, it issue notice to the respondent on the question of admission by speed post. The requisites for which shall be filed by tomorrow. List this matter. A small matter will dispose of. List this matter on. Second July porta karo.
The week commencing 8th July.
List this matter in the week commencing 8th July. That's all.
Lordship, I have filed an IA.
Further proceedings in execution case number 14 of 2015 pending in the court of learned civil judge senior division Athawad shall remain stayed till the next date.
Item number 3.
Item 3.
I am for respondent 2, man. In this case, Lordship, I mean, qualified to take fresh steps in this matter.
You were permitted way back in 2005.
2 weeks time allowed.
नहीं से 2005 में आपको परमिशन दे हितला केते ला 19 वर्ष हेगला 19 वर्ष जदि हेलानी मत कान लागुना आपण आ करिवे बोली नो डिसमिस कर दोटा बेटर हो
On behalf of Mr. Senior Advocate.
maybe behalf of senior advocate, maybe behalf of the chief justice, I don't mind. Yeah, the order was passed on 31/1/2005.
Last.
You have not taken steps for issuance of appeal on notice on respondent number 4.
Present address is.
No. I understand. I have come from the bar, sir. I understand.
So
I
have take the office.
No.
Present address.
No. By order dated 31/1/2005.
Present address.
No. Nothing. I'll dismiss the appeal. By order dated 31/1/2005, the appellant was directed to take steps for fresh issuance of appeal notice on respondent number 4 within 1 week. Failing which, the matter was directed to be placed before the bench for dismissal as against the said respondent. Neither requisites were filed, nor the appeal was placed before the bench as directed. Since 19 long years have passed in the meantime, it is presumed that the appellant is not interested to pursue the appeal as against respondent number 4. Stop. The appeal is therefore dismissed as against respondent number 4. You are appearing for, Mr. Rautre?
What a specific performance of contract.
You are appearing for respondent number or the respondent?
I am only yes, sir. Notice of sufficient of respondent number 2.
And 1 and 3?
1 and 3 କହିପାରିବି.
1 and 3 have appeared. No, you have also appeared for 1 and 3. 1, 2, 3.
1 and 3.
You have appeared. You have already appeared. Since Mr. A. Rautre has already entered appearance for the remaining respondents and the appeal is otherwise ready for hearing, this has not been admitted. Admit. Otherwise ready for final hearing. List this matter in the week commencing.
8th July. 8th July.
Next July. 8th July. Yes. Week commencing 8th July for hearing.
ଆଉ ଟିକେ ଡେରି ହଉ
ନା ଆଉ ଡେରି କରିଦେବେ 3 ରେ କଣ ମିଷ୍ଟର ଡକ୍ଟର
ଗୋଟେ କହିବା ତ ପୁରୁଣା କେସ୍ ଆଜ୍ଞା ଲୋକଙ୍କୁ କହିଲେ ତ
ମୁଁ ସପ୍ତାହେ ଟାଇମ୍ ଦେଲେଣି କଣ ହଉ 15 July. 15 week commencing 15 July.
Item number 5.
Yes, and on behalf of Mr. Matrimonial, I pray the matter will be taken up after 3 weeks because there is a IA 671 of 2004. We have put that for refencing of the suit land. In that year, we need to obtain instruction. What is the status and is it required or not? We'll obtain instruction in that.
If you have not obtained instruction
we have
since for the last again, how many? 18 years.
My lord, we have contacted his brother-in-law has died in a heart attack, so he will be able to obtain.
When did he die? 18 years have passed.
No, recently he has died.
No, maybe 18 years have passed.
My lord.
What is the noting? Yes, let us hear this IA.
My lord, we have filed this IA because as there was a dispute, we have given this IA for refencing of the our suit land. I think objection has not been filed. So
the objection has been filed.
It has been filed.
You have not served copy.
But my late father was the conducting counsel in this matter. My lord, I do not have any. I don't have any instruction right now. I will take instruction as to what is the status of the parties.
All right. Learned counsel for the parties, learned counsel for both parties, request for an adjournment in order to take instructions from their respective clients. Let's this matter next week.
I beg your pardon. Respondent number 4.
I have said that. It is made clear that no further adjournment shall be granted. Yes.
And a copy of the IA, if any objection may be served on.
Yes, sir.
Sir.
Item number 6.
Obliged to.
Yes. Out of the respondents.
Yes, I think you have to take notice was issued through both ways, isn't it?
The notice in the appeal issued to the respondents.
Substitution part is over.
Substitution part is over.
So now this, the noting is appeal notice issued on respondent number 6, the registered post with AD returned undelivered with not residing in this address. So you will have to take fresh notice by giving correct address.
Respondent number 16.
Fresh address by correct address?
In the correct address, within a week we shall file.
Achha, what about the SRs of status quo notice issued on both respondents applicant by court process?
That notice we have received. I appeared on behalf of some of the respondent minors.
Respondents 1 to 14.
No, no, mo 4, 6, 7, 11, 13, 14.
No, initially.
हाँ 4, 14. देखिए,
I will do one thing.
1 to 14.
I will direct him to take fresh notice on respondent number 16.
16.
16. All right. Issue notice. Now, in view of the office note that the notice on respondent number 16 has returned undelivered with a postal report within inverted comma not residing in this address. Learned counsel for the appellant is directed to take fresh notice on said respondent by speed post.
Within a week.
Speed post को जगह बुझिबो?
It is Gonjam.
नहीं, ये इंटीरियर को भी.
The speed post interior.
नहीं, by registered post करो तो. By registered post.
Speed post नहीं.
By furnishing.
Speed नहीं.
City will give it.
Speed post नहीं.
By registered post. By furnishing the correct address. The requisites shall be filed by day after tomorrow, peremptorily. Shri Dayananda Mahapatra has entered appearance for some of the respondents.
Respondents 1 to 14.
Respondents 1 to 14. He submits that the status quo notice has been served upon his clients. In such view of the matter, list this case on, list this appeal on in the week commencing 5th August, 5th August na she jure? No, 5th August tha. 5th August.
Status quo notice ta khali respondent number 4 pe paije. Only respondent number 4 pe paije. But initially I appeared, so it would presume that as if I appeared on
the original appeal.
I received on behalf of others.
I'll continue the status quo. 5th August. I hear interim order shall continue. To the next
may be continue.
I've already said that.
7.
Has this case not been admitted?
No.
Okay.
In penance of the second appeal, the decree law has initiated a execution proceeding.
Well, it has to be admitted.
So that execution proceeding I have filed.
No, but it has to be admitted first.
On question of admission, it can be
yes
noticed and the status quo, because otherwise it will be infructuous.
No, I can admit also. If I find a good ground, I'll admit.
Yes.
If I will not find a good ground, I will not admit. As simple as that.
Yes, the respondent as a plaintiff.
You're confirming judgment.
Confirming judgment. But also, one point, Miller, against a registered document.
You suit for? You are the plaintiff.
I am for the defendant.
You are the defendant. Sheikh Mohiuddin. Mohiuddin na kaun?
Yes. SK Mohiuddin.
Suit for declaration of plaintiff's right, title and interest, permanent injunction to direct the defendant to execute the deed of reconveyance. So suit for a specific performance.
That was my ground. That are not accepted by the court.
Reconveyance in favor of the plaintiff in respect of Schedule A. What happened?
The suit was decreed. The defendant.
You challenged it in appeal.
The decree was here. The trial court found that the unregistered document.
What is this reconveyance? What is that about?
Deed of Miller.
Deed of reconveyance to execute.
Reconveyance means the defendant, the plaintiff had executed a sale deed in my favor. That is registered sale deed. After that, he filed a suit that in exchange of, he created a story that in lieu of this sale deed, I had promised to sell a property in his favor. There he created a document that was not registered. He filed there And that was believed by both the courts. That was my ground that he could have filed a suit for the specific performance of contract.
Let us see the appellate court judgment. Was any point formulated?
No, not formulated, only mechanically believe the confirmed document. The lower appellate court has not exercised his mind, judicial mind, independent mind. That was my case. That he could have filed a suit for specific performance of contract. On a registered document.
Let us see your grounds of appeal.
Yes. And I have a substantial question of law or grounds. Page 11, substantial question of law. So A and D, that is important. A and D, you know.
All are factual. So this sale deed was treated as an exchange deed. Deed of exchange.
No, not exchange. He has
sale deed was treated as a deed of exchange by the court.
Yes. And that was not registered. That sale deed was not registered.
All right. No, only on A.
A and D are not only.
So A as you also detail. Heard. Learned counsel for the appellant. After delivering the impugned judgments and on consideration of the grounds cited in the appeal, same is admitted on the following substantial question of law. Whether both the courts below are were correct in treating an unregistered sale deed as a deed of exchange. That's all. Issue notice. Adjourned respondent. Issue notice to the sole respondent by registered post with AD, returnable within 4 weeks. The requisites be filed within 3 working days. List this matter.
5th August. Commencing 5th August.
Commencing 5th August. IA 1250 of 2023. Notice as above. Accept one set of process fee. IA 636 of 2024. Further proceedings in execution case number 1 of 2024. Pending in the Court of Learned Civil Judge, Junior Division Jajpur, shall remain stayed till the next date.
Urgent.
Hello.
Item number 8.
8
my lords, I am for the respondents. Learned senior counsel Mr. Nanda has been engaged for the respondents. The lordship may kindly call it up some other day.
This has not been admitted.
Not admitted, your lordship.
Let us see whether it will be admitted or not.
As a lordship pleases.
You will come to the picture only if it is admitted, isn't it?
Notice was issued a subsequent date to I have appealed.
Oh, notice was issued on the question of admission. Then he has to be heard. Honorable Justice D. Das has issued no notice. Prayer for adjournment. Counsel for the appellant is present. Prayer for adjournment is made on behalf of counsel for the respondents on the ground of his personal difficulty. List this matter next week.
Item number 9.
Item 9. I have prepared a short note. It is a reversing judgment.
You are the.
I am the appellant. I have filed a short note.
Yes,
My
please.
learned friend has appealed for caveat. I have not filed any IA for a interim order. So after admission, I will serve for. It is against a reversing judgment.
Let us see, Mr. Mahathi, whether it will be admitted or not.
The defendants in trial court and respondent in lower appellate court at the present appellate.
Oh, reversing judgment.
Against reversing judgment, suit for injunction was filed by the respondents. Suit for injunction was dismissed on the ground that the land of the plaintiff and defendant are quite different. The Lone and appellate court, without any new materials, allowed the suit for injunction. Hence, the second will filed by the defendants.
Yeah, but you are saying
Without
something about the
formulating
petition.
any point of determination as required under order 51.
Well, let us for a moment, let us see the judgment.
Appellate.
No, but let us for a moment see the suit for permanent injunction of the suit law with the principle of permanent defense.
Then first come to another trial court.
So the suit was dismissed.
Suit was dismissed.
Mainly on the ground?
Mainly on the ground that there is no cause of action and the land of plaintiff and defendants are quite different.
Far away.
Far away.
Then
The Lone and appellate court, without formulating, without formulating points for determination under required under order 50 rule 31 CPC and reasons thereby has reversed the trial court duty and declared the suit for permanent.
And the Supreme Court has held that if the substantially, if the main points have been discussed. Let me put forth whatever little I know. I am not a giant like you in civil matters, Mr. Mahathi. No. Yeah, recently the Supreme Court, order 41 rule 31 day, Supreme Court has consistently held the view that if the basic points, even though they have not been specifically formulated, if they are included in the judgment and the court has taken care of those things, then non-framing of those points. So as a decision, I used to always frame in the court a single judgment, then points for determination.
My submission that for that point, that aspect has also not been considered.
All right, then what happened?
Each issue has not been considered.
Okay, then what happened? What happened?
Formulating point.
No, what happened to that finding that the defendant's land and the plaintiff's land are separate?
Those are not considered. I will kindly see in the appellate judgment.
Para 15 ko asile. Come to para 15 where the operative portion is there. In view of the above facts and circumstances.
Comes to the conclusion. The trial court findings have not been considered. Only in view of the above facts. Facts have been stated. Then in view of the above fact, this plaintiff's plot note is undisputed and existed towards eastern portion of original plot note by Hon'Ble. I admitted there is no dispute that any temple or defendant have passed any part of said plot by Hon'Ble by Boris and it has been well proved that the plaintiffs are owner in respect of above plot and the defendant without having any title and possession of the same have no locus standi to create disturbance.
All right.
No reasons have been asked.
What are the substantial questions?
Now, substantial question of law C, E, G and L and the other additional substantial will be P and Q in my note page 2.
See whether a suit for injunction simpliciter is maintainable, maintainable no?
Again?
Suit for injunction simpliciter is not maintainable.
Here is a title is in dispute.
Achha.
Sorry, E, G, man.
The factual is your. E will be factual. G.
I, L. L target.
All right, I'm admitting it, we'll hear it finally.
I and L.
All right. I and this PU also will take it up. Because your one of your main grounds is that he has not considered the issues. So we'll take it up. Whatever.
I, L and P.
Lord Sri Maheshwar Mahathi, Learned Counsel for the appellant. Considering the submissions. And on the perusal of the impugned judgments, as also the grounds cited for challenging the same. The second appeal is admitted on the following substantial questions of law. First one. Whether a suit for injunction simpliciter is maintainable in the absence of any challenge to the title of the plaintiffs by the defendants. Where in the whether a suit for injunction simpliciter is maintainable where the title of the plaintiffs is specifically challenged by the defendants. Then whether if the suit was filed, you have said about that consolidation proceeding.
That is pending.
What about what happened during the trial? Whether it was pending or not?
Consolidated proceeding, the decision of the consolidated proceeding, as like a civil court.
Yeah, then they can also decide directly, yes or
that point has not been considered.
whether
If it is pending before the consolidation authority, title question of title doesn't come. Effect they cannot take a plea now without disputing the title for an injunction is
whether the learned appellate court committed an error of law in reversing the judgment of the trial court without formulating points for determination as required under Order 41, Rule 31 of CPC. Since you have appeared for all the respondents.
Through caveat, your lordship.
Since
no, there is no my scope is limited.
Since the respondents have already entered appearance to caveat, no notice need be issued. Extra copies of the appeal memo be served upon. The required copies of the appeal memo be served upon Sri H.N. Mahapatra, who has appeared for the respondents within 3 working days. What is this matter on Kebe? In the week commencing
29th July.
29 July. In the meantime, LCR be called for.
Item number 10. Item number 10. It is suit for partition. The plaintiff is the appellant against a confirming judgment. But the respondents,
ये प्लेस कर दो ना ते कहते रही जो
आगे
पूरा टा प्लेस न करेगी जो तो मेन जिनसे वाला प्लेस कर दो ना
आगे the one Kartika Sai is the father of the plaintiff and Krishna Giridhar died is place. Krishna died. Now the respondent number 1 and respondent 1 is wife, respondent 2 is son. Now plaintiff and Krishna started a joint business in 1982.
You are a stranger to the family.
No, I am plaintiff.
No, you are a stranger to the family. They are a family of Krishna.
No, plaintiff and Krishna are 2 brothers.
Oh, brothers.
Their third brother died useless. So both plaintiff and Krishna started business. Krishna died. Krishna wife is defendant 1, respondent 1, and son is defendant 2. They started a business in 1982. That is bangles, wholesale bangles. And during continuance of business, both plaintiff and Krishna decided to purchase fuel additional land from one Hon'Ble Kumari's house and advance 7,000 as part consideration money. But at the time of rest 8,000, 15,000 was fixed. At the time of payment of 8,000, the restored settlement was executed in favor of defendant 1. And defendant 1 admitted in the WS that both have joint business. Part consideration money was paid by both the brothers. But I have paid the 8,000 from my reason, so the property is not. This is the only point.
So what happened to the suit?
Well, the London trial court as well as appellate court has not considered the admission in the WS in my additional substance question law Roman 4 whether admission of defendant 1 why
My lord, the defendant to supported the claim of the plaintiff. दादार क्लेम को डिफरेंट टू सपोर्ट कला जवाब देलेनी साक्षी भी देलानी सेगलाटा तो जेन्युइन तो किंतु डिफरेंट वन से ओडे कलाने मु लड़ी भी
एडमिशन टा कोठी हला
एडमिशन रोमान खोर अगेन
देन एडमिशन टा कोठी ता डब्ल्यूएस
एडमिशन डिफरेंट इन पारा 9 ऑफ डब्ल्यूएस
अच्छा
से पारा 9 ऑफ डब्ल्यूएस को बोथ को टेक कंसीडर
ऑलराइट
सही गोटिए पॉइंट रे
हेड श्री Maheshwar Mati, Learned Counsel for the appellant, peruse the impugned judgments. After considering the submissions made and on perusal of the grounds cited, the appeal is admitted on the following substantial question of law. Whether the courts below were correct in ignoring the admission made by defendant number 1 in paragraph 9 of her written statement.
Para 9 and para 22.
Para 9 and para 22 of her written statement regarding the proposal for purchase of the suit land by both plaintiff and Krishna.
Right.
And also paid part consideration money. Siddhik issue notice to the respondents by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. Stop LCR be called for. List this matter in the week commencing 29 July.
Item number 11.
Lordship pleases.
Yes.
Lord, here I am the unsuccessful plaintiff as well as the appellant, my lords.
Confirming judgment.
Confirming judgment, my
Yes.
lordships. My lord, here the appellant as plaintiff filed a suit for declaration, permanent injunction, and confirmation of possession, my lord, solely on the primary ground that he has perfected the title by way of adverse possession. Your lordship, if takes the trial court's judgment, the relevant part of it, issue number 3 is the relevant issue, my lords.
Whether the plaintiff has perfected his title.
46, page 46, your lordship.
Yes.
My lord, the last line.
Your lordship, you could prove your claim of adverse possession, which was confirmed by the appellate court. Why should this court interfere?
Lordship, the ground therein taken by the Lanet trial court is that I have paid an encroachment fine pursuant to an encroachment case. And therefore, it is said that I have admitted the title of the state, and therefore my hostile animus, ingredient of hostile animus, is failed to be satisfied.
I think there's a decision in this regard that proceeding under encroachment OPLE Act vis-a-vis the claim of adverse possession. Have you checked up, Mr. Das?
There are judgments, your lordships, against me, my lords. It's a settled law, my lord.
I have never said against or favor.
Lordship.
I said judgments.
Lordship.
I remember having read somewhere.
Yes, your lordship.
I think Mr. Das will be able to clarify because he's, I find that the state is the party here. Obviously. Anyway, so you claimed adverse possession. So there was a proceeding under the OPLE Act.
OPLE Act. I have deposited the fine amount.
Yes.
Because being threatened with immediate dispossession in order to safeguard my possession, I have nonetheless, my lord, paid, and that is a fact admitted.
No proceeding has been initiated to settle the land in your favor.
No, my lord. There was a consolidated patch of land which was under my possession since the year 1950, my lords. Amalnama case the state instituted, and to that total patch of 0.63 decimal, my lord, acre 0.45 decimal in the Amalnama case, it was settled in my favor. However, my lord, even subsequent thereto, the entire patch continued to remain in my possession, both constructive as well as physical possession. There was a bari and a house also, a hutment there over that other area of land, my lords. There was an acquisition proceeding wherein I have been paid compensation. However, the only fact standing against me is to that other extent which was not settled but continued to remain, continued to be in my possession. As regard to those lands, encroachment case under the OPLE Act was filed, and I have paid the fine amount.
You will hear it finally.
Lordship.
Well, here
It's a
finally
small
we
issue,
need
Your
not
Lordship.
admit it formally. We can admit it at the
Admissions.
At the admission stage.
Yes, we can finally. So you argue? So is the LCR required here?
LCR may not be required, my lords.
Mr. Das?
The
What is-
documents can,
I think this is only on that position, whether admission of the title of the state
Yes.
can
Whether-
on your claim for adverse possession.
Whether
What do you say, Mr. Das?
payment,
looking to the findings of both the courts, if the LCR would be required, then only your lordship will.
No, if you say, I can admit it, but since this is a confirming judgment.
my lord
And-
may admit it squarely on this question. That whether on payment of fine pursuant to an encroachment case would lead to an admission of title of the state, and therefore my hostile animus.
I think there are judgments
No.
against you. I'm not very sure.
Absolutely, my lord.
Have been cited.
The appeal court cites those judgments, Your Lordships. There are recent decisions also of this court. If Your Lordship,
Judgments have been referred to.
yes, if Your Lordship sees,
Because you see, the principle of adverse possession is slowly losing its ground.
yes,
It is being watered down considerably.
Next plan.
So let us hear it finally on the question of admission itself. We can dispose of.
Your Lordship pleases.
But if you want LCR to be also called for, we can call for the LCR only.
Fairly, my lord, this can be taken up and disposed. If Your
Yes,
Lordship
that's what I'm saying.
fixes a short date.
Yes. What do you say, Mr. Das?
And your lordship.
Yes. As requested by learned counsel for the parties. Let's this matter. What a short date, Cora? In the week commencing 8th July. For hearing on the question of admission. Get ready with those judgments.
Lordship. Against me, Your Lordships. All against me up until 2022 of this honorable court.
Can't help it.
Lordship.
22 judgment probably I may not have, but I have not been hearing civil matters for quite some time now. But when I was in the district court, I have referred to some judgments in some cases, first appeals. Exactly on this point.
Yes.
Because these cases are rampant all over the state.
Yes, yes.
Where you find a person having encroached upon a government land. There he claims that claims adverse possession.
Yes.
And another aspect is also there. The period of limitation will be more. It will not be 13. It will not be 12. It will be 30.
30 years
30,
against
isn't
the
it?
state.
So, let us see. All right. So you are sure that the LCR is not required?
The findings are there.
Take it. Yes.
Item note 12.
Well, we are not the plaintiff is in appeal against a confirming judgment.
Yes.
Here, in fact, the suit was filed for specific performance of contract.
Yes.
Fact of the case is.
What was the contract?
Suit for
Contract for sale.
Contract for sale.
Yes.
There were two plots in the agreement. One is the consolidated plot and another is non-consolidated. So there was a clause in the agreement that after this agreement, the person who is to sell the property, he will apply for necessary permission for sale of the property. After getting the permission only, he will.
Right?
No, it is under the Consolidation Act.
Oh, that permission. Yes. I have dealt with a similar matter in your case very recently.
But it is a different aspect because I am.
That permission aspect.
Yes, yes.
Isn't it?
That is a different aspect.
There was a permission thing there.
No, there is no permission. In fact, in that case, the question was whether unregistered agreement can be.
No, that's true. But there was some sort of a permission required. One party had applied, the other party did not cooperate. That was your ground
that was hard by your lordship, but could not be disposed of.
No, judgment could not be disposed of. Whether the payment of stamp duty and penalty will, I held that it will not cure the defect under section 53 capital A.
Seta judgment is. Sethre kintu permission katha kisi nahi.
Acha, tala agu kothra confused.
Agu takare uthithela kintu seta judgment hei parni.
Acha. So now this was contingent upon obtaining permission.
Before permission, agreement was executed on the ground that after getting the permission, sale deed will be executed. So in the meantime, He applied for permission, but permission was refused. In fact, under the Consolidation Act, there is no provision for such permission. 34, 35, etc. provides that one who seeks to transfer
Adjourning permission darkar nahi hote?
No, darkar nahi. Or state will take care of the things. There is no provision for any permission. It's a different aspect altogether. So it was also pleaded after rejection of the permission, there was a further agreement, the second agreement, where the plot was withdrawn. The plot for which
Permission was required.
that was withdrawn, and the non-consolidated plot remained intact, with even a part of the consideration was also taken back.
Okay.
But after some days, when the sale deed was not executed, the suit was filed. In the suit, two prayers are also made for specific performance of the contract and recovery of money, alternatively. Now, the learned trial could dismiss the suit, saying there was no, because the defendant, he took a plea of borrowing of money and entirely disagreed with the learned trial could dismiss the suit. Thereafter, appeal preferred. In appeal, what has happened? An application under Order of Rule 27 was filed.
Additional evidence.
Yes. Two documents. One is the application for grant of permission, which was filed by the defendant himself before the Tahsildar. Second one is the order. That has been dealt with. Kindly have a glance. Page 7 of the surrounding page 13, internal 7, paragraph 9, that has been dealt with.
Yes.
Last part.
Yes.
Filed a petition on the counsel for the plaintiff, filed a petition on prayed to adduce two documents, certified copy of the order sheet in 4 case number so and so, and certified copy of the petition. Then these two petitions were allowed also. Kindly have evidence. That is page 16 and 17. Running page 16 and 17, internal 10 and 11.
10 and 11, yes.
Last part. Page 10, last two lines. Hence this court. Hence this court of the is of the opinion.
Insofar as
Once that for sale of the property is concerned, it is
gone.
It is only with respect to the
refund of money.
12,000 rupees.
So that there is no bar.
There is no bar. That has been dealt with.
Let us see.
Guys, the question it is being raised.
How has the appellate court dealt with it?
Yes, by running page 19, internal 13.
Yes.
But the para begins with but.
But again
the question comes.
Place this entire paragraph.
Yes,
because he has dealt with section 49 here.
Paragraph 12, I am placing. Paragraph very clear that an agreement, that an unregistered document may be received as evidence of a contract in a suit for specific performance or as evidence of any collateral transaction not required to be effected by registered document. But that does not mean mere filing or exhibiting an unregistered document itself enough to prove the collateral transaction between the parties to the document. Rather, the unregistered document can only be used for corroborative purposes. Hence, the plaintiff exhibited the unregistered document relating to the payment of consideration money in view of the agreement for sale of the suit property. Then the same is ipso facto is not enough to prove the all the ancillary contents not required for registration. Then payment of consideration, which was decided by the learned trial court, it has been quoted. In fact, the additional two documents which are marked as exhibits 7 and 8, because I am harping on those two documents that were taken consideration on page running page 21 last. Apart from the above. The last two lines.
Yes.
Apart from the above, though the plaintiff's document marked as exhibits 7 and 8 show that the same was prepared after exhibit 1 and 2, and by the petition marked exhibit 8, defendant sought for permission to sell the suit property to the plaintiff, whereas there is no recital in exhibit 8, certified copy of the petition of the defendant before consultation authority to sell the suit property to the plaintiff, that the defendant received rupees 22,000. Now, once on the basis of the same agreement, he applies, means the existence of agreement is admitted. Once it is admitted that there was an agreement, is it at all necessary in the petition for permission to say that I have received 22,000? This is the only mistake he has committed, and both the subsequent documents which are marked as additional evidence that has been rejected on the same ground. So my submission is an admission. Once it has been admitted in evidence, this is proved as an admission. I need not even prove payment of money was made. Thereafter concludes that since there is no recital in the petition itself, therefore it cannot be taken into consideration.
So substantial question number C will do.
Yes, only
C.
refund of money. Yes.
All right. That's Sri D.P. Mahanti, 11th counsel for the appellant. Produce the impugn judgments, considering the submissions, and on the perusal of the and the grounds cited, comma, the appeal is admitted on the following substantial question of law. The ground C util election theory. Whether the first of law will be pertinent. Yeah. Issue notice. The respondent, sole respondent.
Sole respondent.
The registered post with AD returnable within 4 weeks. The requisites be filed within 3 working days. LCRB call for list this matter on
5th August.
5th August. It will be commencing 5th August. Yes.
I do not 13.
May please, Your Honor. Well, this is a confirming judgment, and I am the defendant in a suit for petition.
Suit for petition.
Suit for petition. Well, just have a glance over the genealogy at page 16, the lower trial court judgment, 16, page 16.
Court judgment. Trial court judgment is that running page?
The running page 16 and internal page
Running
3.
page 16.
16.
Okay.
It starts from page 40.
Yes. Lingaraj Naik.
My lord. He is the common ancestor.
Yes.
My lord, the first wife dead. There is his son, the only son, Arjun dead. And his Arjun dead. Thereafter, you will see the Baijanta, the plaintiff. The widow, daughter-in-law of Lingaraj Naik. He has filed the suit against me, that is the second wife and daughter. Well, I am the defendant. My plea is that after the death of
suit for
petition.
All right.
Petition. She is claiming that I am having a half share. So I have filed the written statement stating therein that after the death of Arjun, the widow left the in-laws house with an undertaking, with a note that he cannot claim any property, he cannot claim any share over the property, and towards her he has been granted a maintenance, one-time maintenance by Lingaraj Naik. That has been marked as Exhibit A. And in lieu of that, he has said that she shall not claim any share over the property of the Lingaraj Naik, his father-in-law. The Lingaraj Naik death.
What is the legal sanctity of such a?
Yes, that. Well, the Lion trial court held that this document.
You admit that this is an ancestral property?
Well, still you are not saying it is the. We are saying that it is self-acquired property, and there is no evidence that whether it is ancestral property or self-acquired property. It is taken from the appellate court. Still, the appellate court held that as the document shows that it is self-acquired property. There is no evidence. No evidence was laid whether it is ancestral property or self-acquired property.
This is purely factual, Mr. Patnaik. Purely factual.
Well, then
you had evidence.
No, the Lion trial court held that the document which has been exhibited by me, Exhibit A, that is by virtue of the family settlement deed, it needs registration. It needs registration. As this same has not been registered, it cannot be taken into consideration. And the Lion trial court held that it is a relinquishment deed. Contraband, but it is a relinquishment deed. And that document has not been registered on, which is required to be registered on section 17(1)(b). It is held that. So, because of the non-registration of this said document, it cannot be relied upon. So, the trial court held that it is a relinquishment, and the first appellate court held that it is a deed of family settlement.
Deed of
Family settlement deed.
Kachapatra.
It is he held that it is a Kachapatra, family settlement deed. So it is, actually, this is that exhibit A, I am also having it.
Let us see.
It needs interpretation.
No, let us come to the trial court's order.
Trial courts are here and let's
Trial court say, issue ta dekhiba. Whether the suit schedule is partible among the.
Whether the suit schedule and properties are partible among the plaintiff and
Issue
defendant.
number 3 Let us place the issue number 3.
My lord. Relevant.
Just a moment, Mr. Patel. Just a moment.
My lord.
Yes. Mr. Das, have you got the file from court number 10? That file?
Yes.
Where Mr. Mahanti is waiting? All right, let me complete this. I'll take up. Yes.
My issue number
3 is relevant.
Relevant para is page 25. At page 25, my lord, just available.
25, yes.
When it starts from page 24, paragraph 10. And relevant observation is at 25. Page 25. So in view of the non-registration of the document by the exhibit A, and in keeping in view the aforementioned decision of the Honorable Court, the Odisha High Court judgment has been relied upon. Exhibit A, which is not a registered one, cannot be considered to be valid one, and accordingly, basing on the said document, it cannot be said that the plaintiff has relinquished her share over the movable and immovable properties over in-laws. So trial court held that it is a relinquishment, and when it is a relinquishment, it is required to be registered. So when it is an unregistered one, it cannot be relied on. What is appellate court held here, Lordship? It is at page. Page 40. Page 40. The first appellate court's finding.
Yes.
Paragraph 30. On perusal of exhibit A, it is found that the said document is not a memorandum which was prepared after the family settlement is arrived on. Of course, the plaintiff had no antecedent title at the time of the preparation of exhibit A. But she had relinquished all her share in favor of her father-in-law Lingaraj. So the relinquishment resulted in extinguishing a right of plaintiff over the suit land. As the settlement has been reduced into writing, the same requires registration. In the case, the one Supreme Court and High Court judgment has been allowed. Now the question arises whether exhibit A can be used for collateral purpose as provided in section 49 of the Registration Act. Not a single question has been put to the plaintiff PWN disputing her possession over the property after the death of Lingaraj. Even if exhibit A can be utilized for collateral purpose, more particularly regarding possession by the plaintiff. But in this case, the defendant have failed to prove that after execution of the exhibit A, she had finally left her in-laws house, relinquishing all her share.
This is the factual aspect. This is the factual aspect. So you are required to prove it by adducing appropriate evidence.
There is no evidence actually, but the finding has been arrived at. Even your lordship, last word, there is no evidence on record that, well, last sentence, there is no evidence on record that the suit land is ancestral property, and as the same has been recorded in the name of Lingaraj, the same shall be treated as a self-acquired property. Accordingly, London lower court has rightly allotted half share.
What is the law relating to presumption? What is the presumption?
Well, in
the absence of any evidence, the property is to be treated as belonging to the person in whose
name
it has been recorded.
The property stands recorded.
Yes. So what are your grounds?
Well, my grounds are whether that document requires registration or not. First, second, your lords, in absence of any, I have not framed that issue a substantial question of law. But it can be taken into substance to my lords whether the document exhibit A needs to be registered.
What is your stand on that? He says that it can be used only for collateral purposes as per section 49 of the Registration Act.
My humble submission is that
So what is that document according to you? If it is not a deed of relinquishment, if it is not a deed of family settlement, what is it?
he has signed the document in presence of the witnesses and in presence of his father-in-law.
So did you examine those witnesses?
The father-in-law, after the death of the father-in-law, he has filed the suit. In 2013, the father-in-law died.
Yes.
Thereafter, the
document is the of the year
86.
86. All right.
86.
So it was executed in presence of two witnesses.
In presence of the witnesses and Sir Lingaraj Naik and this widowed daughter-in-law. And one stamp paper was there.
Yes.
Is there. And he has signed it in presence of the witnesses and Lingaraj Naik, the common ancestor, has also signed this document.
What according to you is that document?
Well, that document is the only declaration that I shall not claim, and he has by this document, Your Lordship, she has been given the maintenance. For the rest of
Can the I asked you at the outset, can the plaintiff or that lady, can her right over the property be
can be taken away?
Can be taken away by such a statement that I shall not claim any share in the property. What is the legal sanctity of that document?
Your Lordship may examine that matter.
That Your Lordship
Will examine that matter. Section
I am
4 of
asking you
the
a
TP
direct question.
Section 4 of the TP Act stares at that document.
That is why I am asking.
Your Lordship will examine. Section 4 of TP Act will protect her. Nahi.
Can I place the document, Your Lordship?
All right. We'll say what is the nature of that exhibit A, whether it is a relinquishment deed or a family settlement. All right. All right. But Sri Somendra Patnaik, Learned Counsel for the
Settlement accept you say your relinquishment will not. Section 4 will stare at.
And that is what I, from the very beginning, even before he began, I posed that question to him. Anyway, let us see that exhibit is a substantial question of law. It will cover everything.
How did that happen?
I would joint family evidence ne seta jodi chahe me koi
No, ऐसे हम नहीं करेंगे कौन? अब नंबर तो माना नहीं.
Additional ground nahi hai.
Because exhibit A, your entire case is based on exhibit A. So we can
remand. Hajur remand କରିବାକୁ ପଡିବ ଏଇଟା. ସେଠି ଆଉ ଥରେ
देखिए I have to see that exhibit. I have to read it myself.
ଅଛି ତ ମୋ ପାଖରେ ଏବେ ଅଛି।
ଥାଉ ମୁଁ ଦେଖେ ସବୁ ଦେଖିଲା ପରେ ଦେଖିବି ଏଇଖିଣା କାହିଁ ଦେଖିବି 2023 ମ୍ୟାଟର ମୁଁ ଏଇଖିଣା କାହିଁ ଦେଖିବି 2003 ରୁ ଅଛି ମୋ ପାଖରେ ଏଠି ବନ୍ଦ କଲୁ for the appellant to use the interim judgments considering the submissions and the grounds raised. The appeal is admitted on the following substantial question of law. এটা করে দিন তো B যেটা আছে সেটা করে দিন তো है ना B कर देंगे for the time being we are only taking up exhibit A part जोटा लिखेंगे B issue notice कितने जन appellant respondent अछंती नहीं जन लिखिले issue notice to the respondent by registered post with ID returnable within 4 weeks the requisites be filed within 3 working days. Call for the LCR. This matter in the week commencing August. 12th August. Bye.
Court number 10, item number 55.
In 2015, some constables got promotion as havildars. 15. Recently, they were reverted. 2023, they were reverted. And another set got promotion. Human reverted, they came before lordships. Your lordship said that if you are not reverted, not reverted. That virtually that did not help him. Now, recently, a set of recruitment started. Promotion. From constable to havildar. And these 5 persons who are reverted and did not make those who got promotion as parties, obviously their original case will be hit by non-jointer. Because see the जितने से पिला गुना को उन्हें की एसिडी पाइबे ना से कथा कॉले ना आउट ऑफ फ्रेश रेट फाइल करी हजूर से ओटा ऑर्डर कॉले जे 5टा पोस्ट हम पे खाली रो माने आमो भितरु माने हमें 10 वर्ष जूनियर सेटा को तो पुलिस वाला बुझिबे ने से तो कहला जे ट्रेनिंग को जाई परिबे अरे जदि प्रमोशन हबो से वैकेंसी टा पुल अप हबो नै पांचटा वैकेंसी अभी ट्रेनिंग दे पाइले तो हजर जे ट्रेनिंग पठेले नै सिलेक्ट हेचो हम ना अछि मु देखौ छ annexure 1 is the document some people are reported
Annexure 1.
1
Your name is included here.
no I am not one of them annexure next annexure others got promotion their senior batch our rank senior batch.
You have no dispute
no dispute. But they have obtained an order from your lordships that pasta vacancy rakho. And obviously promotional post pasta rakho.
What is that promotional post? Head
Havildar.
Havildar.
Again, promotion dala ko अच्छी से list रे. किंतु हमको
Where is that list?
A list is at page 16.
Page 16. This is available regarding holding a promotion board for filling up a vacancy. So you have been considered. You have been brought under the zone of consideration.
Oh, yes, we are already virtually have to go for training. किए बारो बतई दला जे से पोस्ट कहछन पांचटा पोस्ट is subject to completion of training successfully then I will get promotion. Training रो अटकौछन पठौना हजर टिके सेटिक खाली
very कोड पठौना बोले अपन खाली आवर कर
हम सर्विस बुक लिखि दला जे कोर्ट ऑर्डर अछि एठी किछि नाही एठी कोन है एठी 38 लोक ना एठी देखो पेज 18 रे 19 टा पिलांग बलांगी रे 19 टा पिलांग पठेल हमको रख दे जस्टिस correction.
Yes, Mr. Das. This will be without prejudice.
Fair is to consider for that.
Yes. No, Mr. Das.
Yes.
We will, this court will permit them to attend training. That will be without prejudice.
Innocuous order, जो Justice रथ करथले से ASI ट्रेनिंग बेले से इंट्री मॉडल ता देखन जो ASI लिखा आइछ ना सेटा हविलदार लिखि हविलदार ट्रेनिंग
मोर निजे ऑर्डर पास कर
देख
कोने निजे ऑर्डर पास कर
परसुएसिव आपण ए ऑर्डर करछन
No, Mr. Wade, this is just a lighter.
कौन करो विकेट
Lighter when they कहली आज्ञा
अजे से गोटाई तो वार्ड कहिछि डैनियल प्रिवेल्स मो बस्ती कोर्ट रे सेकंड अपील जाको योर लॉर्डशिप टेकिंग अप एंड अंडरस्टैंडिंग ऑफ फॉर्मुलेटिंग इट डैनियल ओनली प्रिवेल्स
ए सुबिलानी
डैनियल प्रिवेल्स हजूर तळ कोर्ट रे एठी बाहर आस्तले एते जल्दी जोर धरि परंदने हजूर जाई पेपर तो आछचंदी बोली लॉ सेक्रेटरी जगह धरि परचन फटाफट सेकंड अपील सेकंड अपील जाको हजूर मु देखिछि
लर्निंग इज नेवर ओवर
ना लर्निंग इज कंटिन्यूअस ए मोर मने पड़ला काई सेक्शन 4 कहली टीपी एक्ट लॉ कॉलेज पड़ला मूड कोर्ट कंपटीशन नहीं थला ऑल ओडिशा मूड कोर्ट रे आई स्टूड फास्ट बिकॉज़ एई धारी को कहली जे सेक्शन 4 स्टेयर्स एट इट मियर रिलिंक्विशमेंट इज नॉट माने किछ तेणु से
क्वेश्चन
गवर्नर पार्टी पाई खेली तेणु कहि दिले
नहीं No, we learn, sir. We learn from you. एतरे किछ पया कोन Sri Ardas accepts notice. You accept notice for all?
Yes, he will take.
Accept notice for all the opposite parties. 3 extra copies of the writ application be served upon Sri Das by tomorrow.
Well,
by tomorrow. आइए परंतु है ना heard केते कर दियंतु आइए ये रे list this matter on go date करन when shall we keep it to
well
after date करना
10 days after
9th July sir 9th July in the meantime
August मासे कर दे August
कर दो ना कर दो 5th August
ये तो सेकंड अपील सो वादाई तो मच
in the meantime the petitioners shall be permitted to undergo DIC training for Havildars pursuant to the order dated 22/5/2024
it is
of the IG of Police Protected Personnel Odisha.
It is commencing from 19th.
At the Purvuru Khali Kota line it is submitted that the training program is scheduled to commence from 19th of June. Hela last look on the this order shall not be, this order shall be without prejudice.
Prejudice, without rival contention.
Prejudice to the rival contention raised in the writ application, sir.
They may be sent for training.
Let us set the order specifically. Sir, कौन लिख ले? नहीं, तब पूर्वटा पढ़ो.
In the meantime, the petitioner shall be permitted to undergo DSC training for Avildas.
Pursuant to order rates one, sir.
2024 of the idea of personnel, Odisha Central. And the police personnel.
तापरे? Further, you know, without prejudice, sir? Further. No, further go.
This order shall be without prejudice to the rival contention raised in the writ application.
Sir, protecting both sides. Yes. Urgent certified copy be granted. Yes.
Trade for in course of payment.
चार्टा बारे नहीं से कर दे.
It will be uploaded.
Upload कर दे.
Upload होगा तब कर दे. अजी यही जो है. Urgent certified copy be granted in course of the day. Further, the opposite parties, authorities shall also act upon the uploaded copy of this order.
Item number 14.
May I please, Lord, sir? In the first order, I was seeking for time because
yes,
Lord's homework is necessary in this case as the respondent has already entered appearance without notice. Therefore,
respondent has appeared upon.
Yes.
You want time?
My lords.
All right, this is 2023 matter. All right. As requested by Learned Counsel for the appellant. Is this matter 21 next week?
First week of July.
In the week commencing 8th July. Yes.
Item number 15.
My lord, respondent advocate Mr. Sumasan Mahanti expired a month ago, my lord. I received instruction for adjournments, my lord. My lord.
All right. Who's for the appellant?
One week after.
All right. Oh, your good name, sir?
Kirtan Badhai. Kirtan Badhai.
Kirtan Badhai. See, Kirtan Badhai has entered appearance for the respondent in place of the previous counsel. He requests for an adjournment. Let's this matter. Karo, what you karo?
The week commencing 15th July.
The week commencing 15th July.
Revelation.
Item number 16.
ये कितना दीजिए ना? 19 है. अच्छा हो. तो ये तो week पर है. मेरा पूरा week सारा पहन. अच्छा हो. चलो ठीक. सब hearing धरिया कल को. Yes, Mr. Das.
Lordship, please, my lord. My lord, here appellant is the plaintiff confirming judgment.
You are the plaintiff.
Yes.
Confirming judgment.
Confirming judgment.
Suit for?
Suit was for injunction simpliciter, my lords. Plaintiff is the son, only surviving son, my lords, of defendant 1. Defendant 1 is the father. And defendant number 2 to 4 are the sisters, my lords.
Siblings.
Sisters. Own sisters, my lords.
Hello, sibling or what?
Yeah. Suit property stood recorded in the name of defendant number 1, father. However, the claim of the plaintiff was.
What is the nature of the suit property? Ancestral or self-acquired?
Self-acquired property.
Self-acquired. It's an admitted case.
Yes.
Yes.
And my lord, plaintiff took loan, a joint loan along with defendant number 1 to purchase the property and thereby construct a house.
That very same property?
That property, my lords.
Achha.
Thereafter, my lords, the daughters were married. Their shares, so far as those ancestral property and some of self-acquired properties as well, were given to them. Some with knowledge and some without knowledge of the plaintiff's son, my lord, only surviving son. My lord, here.
So when you say about knowledge, obviously you are referring to the self-acquired properties.
Self-acquired properties. Self-acquired properties.
So gift कर देल ना कौन?
Sale कर देले गया.
नहीं तको भूषण मन को कौन करे?
Sale नहीं गला. बापा मां sale कर देले.
Sale देखी थी वो?
देखी थी आ गया. Sale हो गया in the town. Borompur town property. Some properties have been sold and they have also subsequently sold. So far as this property is concerned, my lord, defendant number 1 along with me, who happens to be the son, were residing in the property. That's an admitted fact. Suit was only for injunction, my lords.
How can you bring a suit for injunction against the title owner?
Lordship.
He is the title holder who, as you have admitted, is the self-acquired property.
Is the recorded owner, but I have taken loan jointly with my father
Mortgage
to purchase this particular property.
Correct.
Thereby, I have serviced those loans. Construction also have been made. I was running my business in that premises.
You
as a
took a
proprietor.
loan, but you allowed the property to be recorded in the name of your father.
Yes, that is the case, my lords.
Now suddenly you wake up from your slumber.
That is the case.
Anyway.
Lord, so the only issue
So
here.
what happened in the trial court?
Lord, the trial court held the injunction suit to be not maintainable. Holding that, my lord, in a cursory manner, it has rendered a finding as to the title. If your lordship only sees page 41, the relevant part of the finding, page 41.
Page 41, yes.
41, trial court. The second paragraph, my lord.
What is this, what is this quotation?
Anthula Sudhakar, my lord, that case has been relied upon.
What is the issue? I don't know.
Therein, my lords, the issue was in what are those instances in which in an injunction the title issue must be gone into. Say there was a cloud over the title, that the title issue has to be gone into. However, the Supreme Court there clearly states that in absence of any relevant pleadings, specific issues to that effect, chance given to the plaintiff to adduce evidence so far as title is concerned, the finding as to the title should not be rendered.
No, but before I allow you to go further,
Lordship,
tell me what was the cause of action?
Lord,
why did you come to the suit?
My lord, my possession was in question, my lord. They were taking steps to dispossess me. But coming under the influence of the daughters, the therefore, my lord, an injunction suit is all I instituted.
Is it a dwelling house?
Dwelling house, my lords. It was a dwelling house.
All right. Then?
It's paragraph, if I may place, my lord.
Yes, please.
In the present suit, it is an admitted fact that both the plaintiff and defendant number 1 are residing in the suit building. Hence, both the parties are in possession of the suit property. It is forthcoming from the pleadings and evidence that of the parties that the sale deed as well as the ROR stand recorded in the name of defendant number 1. Defendant number 1 has also claimed his title over the suit property in his written statement. No counterclaim, my lord. In his written statement, by virtue of a rival pleadings, he asserts his title. Therefore, although the plaintiff is in possession,
you are not disputing his title also. Are you disputing his title?
ROR title achi nankaro.
No, have you specifically disputed his title?
The record states that the ROR stood in the name of the father. It was also purchased in his name. All my claim was that I have made arrangements towards that purchase.
No, I asked this question because you raised the question of counterclaim.
Lordship,
that he has not filed any
counterclaim. Apprehends dispossession of the suit property.
Yes.
Thereafter, the last line, if your lordship reads,
as a sale deed and ROR of the suit property stand recorded in favor of the
defendant number 1, prima facie, a title of defendant number 1 is made out, and it is presumed that defendant number 1 is the owner of the suit property, and in such a case, the plaintiff cannot restrain the real owner of the suit property unless it is held that plaintiff is the real owner of suit property. As stated above, the question of title cannot be decided in a suit for injunction simpliciter, and the plaintiff is required to amend the plaint and incorporate the claim of declaration of title and possession. In the present case, plaintiff has not amended the suit to incorporate the relief of declaration of title interest over the suit property, being fully aware of the claim of the defendant number 1 over the suit property. Hence, in view of the position of law laid down by the Apex Court as mentioned above, a suit for injunction simpliciter is not maintainable, and plaintiff, not being the real owner, cannot injunct the real owner.
Have you examined the point from the view? Have you examined this case from the point of view of it's a dwelling house?
Lordship,
you are being sought to be ousted from the dwelling house, isn't it? Being member of the family, you are not a stranger. Have you examined it from that angle?
No.
What will be the effect of it? You should. Yes. Then what happened? No, it was dismissed. Then what about the appellate court?
Appellate court has affirmed, my lords.
On what ground? Points for point किसी formulate करते हैं तो अच्छा So the pleading entitled to permanent injunction is from alienating such a sale.
That cannot be injuncted against the real owner. If your lordship for a moment also sees page 37, the issues that the trial court frames.
Yes.
Issue is only with regard to whether the plaintiff is entitled to permanent injunction, restraint.
Same thing has been copied verbatim by the appellate court. Just now I was looking at
Lordship,
the point for
Lordship.
formulation, point for determination actually.
So even so far as title is concerned, no specific issue was framed.
So what are your substantial questions of law?
That, my lord, your lordships will find at page 12, Roman 2.
What about the dwelling house thing?
Dwelling house, my lords, I'm not exactly.
You are residing there.
Lordship.
You are a member of the family.
Lordship.
Property may not belong to you. Your possession could be permissive. One may say so. One may say so. You are a member of the family.
Lordship.
You are, by way of the action that you claim your father has taken, you will be ousted from the property.
Yes.
So your argument should be that you are entitled to claim injunction.
Yes.
Anyway, we'll admit it on this.
Lordship, when taking cue from this particular finding of the learned trial court as well as the affirmation order of the appellate court, a sale deed has been executed by defendant number 1 in favor of the daughters.
या परे
आ गया ए फाइंडिंग टा आसिला परे गुटे सेल डीड एग्जीक्यूट करले बापा in favor of the daughters, and thereafter the daughters on the strength of that sale deed have filed an eviction suit. That eviction suit is now pending.
That will be decided on its own. You have not claimed any interim relief here.
No, your lord. So, my lord, if there might be subject to your lordship's consideration, an additional question, substantial issue which might need your lordship's consideration is whether this finding as to the title will be operating as res judicata. Otherwise, my lord, I might.
Res judicata means how? Res judicata in respect of subsequent suit.
The title.
Title in respect of in the subsequent
suit.
But we are in the former suit now.
Yes.
Aren't we?
Lordship.
So you can raise that plea there in the subsequent suit.
As a lordship.
Isn't it? We'll just admit it on that ground. It is always open to the court to take any further ground. Also.
Yes.
That's Sri Abhishek Das, learned counsel for the appellant, pose the impugned judgments, considering the submissions and the grounds raised. The second appeal is admitted on the following substantial question of law. Page number
12.
Page number 12 or 2, Roman 2. Issue notice to the respondents by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. Call for the LCR. Business matters. August. 12th August. In the week commencing 12th August. Yes. You also examine that aspect. Yes. I think, but I'm not very sure. I think Mr. Mahathi and Mr. Bose, they will be able to guide you. Guide me rather. In the case of this is a case of family. After I have passed that order. The case of family, father attempting to oust the son. So whether he can seek an injunction, even if the property is recorded in the name of the father and he doesn't dispute his title, without disputing the title, in a dwelling house, what would be the effect? It is not that as simple as that. Khali gote padya jamita podichi se jamita bapa na record heichi mate setu mundam injunction kori paribi nahi se gote bappa. But this is a dwelling house in which I am also staying, because that is from the pleadings. I find it is reflected in the trial court's order also that you are also residing in that property.
It's an admitted.
Isn't it?
Possession is admitted.
What could be the point of law in that regard? Please examine.
Lordship.
And if necessary, we'll frame an additional issue. Yes.
Item 17.
Year law is defendant number 3 is in appeal against a confirming judgment.
Defendant number 3.
Here
alone. Defendant number 3 alone.
alone.
ମାନେ ରବୀନ୍ଦ୍ର କୁମାର ମହାପାତ୍ର।
Again. Here, in fact, interpretation of two documents is necessary. And as the lordship knows, where the courts have committed error in interpreting the document, that can be a substantial question of law. Now, the fact of the case is this plaintiff, who is the defendant number one, respondent number one in the appeal, he files a suit saying that he had got a property measuring 400 decimals in total in a particular plot. Out of that 400 decimals, he executed a power of attorney in favor of the defendant number one to transact the property in respect of a part of it that is only 283 decimals. And the
what is the total extent?
400.
400 decimals.
400 decimals. He executed a power of attorney in respect of 283, leaving 117.
The power of attorney in favor of whom?
In favor of defendant number one.
Defendant number one, means Suresh Kumar Padhi.
Again.
Yes.
Suresh Kumar Padhi.
Yes.
Thereafter, two sales have been effected. The defendant number one, he has executed one sale deed in favor of defendant number two. Then another is defendant number three.
Yes.
I am concerned with this.
200 kete decimal bhituru.
The question is not now the plaintiff claims.
No, see you sell data kale. See 200 kete bhituru to karthibe. Jetiki tak power of attorney.
मैं कहूँ करथिले बोली. But plaintiff says it is beyond.
Acha. So plaintiff is challenging that transaction
on the ground that the property which was left out of power of attorney, that has been transacted.
Okay. Okay.
That is the issue. Now this defendant number three claims, because I am not appearing for defendant number two, his claim is a bit different because he says along with the power of attorney holder in his sale deed, owner was also a party which was not there in my sale deed at least. So in this sale deed in favor of defendant number three, which was exhibited as exhibit D, he claims that it is in respect of the property for which power was given, that is 283. Now, two documents are under consideration. My substantial question, or I am claiming here that the description of the property which is given in the power of attorney and the description of the property which is given in the sale deed, whether it can be said that in fact the property has not been transferred for which he was permitted to transfer. Now, I have got the certified copies of both the documents. Exhibit 1 is the power of attorney. That is the
difficult
schedule of again.
ଆପଣ ଅଭ୍ୟାସ ହେଇଛି ଆପଣ ପଢିଦେବେ ଏଇ ଯେ ପଢିବା ଭାରି ଡିଫିକଲ୍ଟ
ନାଇଁ ମୁଁ ଖାଲି ସେଟିକି ପାର୍ଟ ଟା ଖାଲି
ଏଇଠି ଗୋଟେ ଲେଖା ହେଇଛି ଏକର 0.400 ଦକ୍ଷିଣ ଦିଗ ମଧ୍ୟରୁ
ଦକ୍ଷିଣ ଦିଗ ମଧ୍ୟରୁ 117 170 ପୁଣି 117 ଟା ଓଡିଆରେ ମାନେ ସଂଖ୍ୟାଟା ପୁଣି ଅକ୍ଷରରେ 70 ହେଇଯାଇଛି. That is a different issue that was also taken care of. And trial court says it's an accidental error. Anyway, ଏଥକୁ 14 ଟାକୁ description of
ଯୋଉଠି ଫିଗର ଥାଏ ସେଠି
ୱାର୍ଡଟା କଣା ଯାଏ କିନ୍ତୁ he has committed a mistake there and that has
anyway
ଚୌହଦି ପୂର୍ବ ପଶ୍ଚିମକୁ ଉତ୍ତରକୁ ଏହି ପ୍ଲଟର ସମ୍ବନ୍ଧ ଭୂମି. That means there are properties out of this plot towards all these three directions.
Yes.
ପୂର୍ବ ପଶ୍ଚିମ ଏବଂ ଉତ୍ତର ଦକ୍ଷିଣକୁ ରୋଡ ଭୂମି ଛାଡି ଅବଶିଷ୍ଟ ଭୂମି
ମ୍ୟାପ ନଥିଲେ ତ ଅସୁବିଧା ଆଉ
ମ୍ୟାପ ଦିଆହେଇନି ଏଥିରେ ଦିଆହେଇନି ସେଥିରେ ଦିଆହେଇନି
ମ୍ୟାପ ନହେଲେ କେମିତି ଜାଣିବି
ସେଥିରେ ସେ ଡେସ୍କ୍ରିପସନ ଟା ଦିଆହେଇଛି ରନିଂ ପେଜ ଅଛି 51 schedule of property.
Unless you can show that the finding is perverse, the interpretation is perverse, why will the court
perverse? It is there. That's why I am showing the description. Set what a running page description there. Pura rakava 400 decimals. There is no reference to the part of it which was permitted. Purba dakshina konaru 331 decimals. That means Purba, which has been reflected in the power of attorney, that there is existence of the property which has been left out. That reference is also there in the sale deed. From the permitted area, some property.
No, Mr. Bhanti, I will do one thing. You will have to prepare a map. ନହେଲେ ବୁଝି ହବନି.
ଆଚ୍ଛା ଠିକ ଅଛି.
ନହେଲେ ମୁଁ ଚିନ୍ତା କରିକି କଳ୍ପନା କରିକି ମୁଁ କେତେ କରିବି.
ଠିକ ଅଛି. ମୁଁ
ଗୋଟେ ମ୍ୟାପ ପୁରା କରିଦିଅନ୍ତୁ.
ଆଜ୍ଞା.
ପାର ପାଟର୍ନରେ ଯାହା କରାଯାଇଛି ତାର ଚୌହଦି ସହିତ ତାର ପାଖ ଆଡଜର୍ନିଂ ପ୍ଲଟ ଥିଲା ଯୋଉଟା ରେଫର ହେଇଛି ତାକୁ ଆପଣ ଖାଲି ଦେଖେଇ
ପାୱାର ମ୍ୟାପ ତ କିଛି ରେଫର ହେଇନି ମୁଁ ଦେଖେଇଦେବି ପୋଜିସନ ଟା ଦେଖେଇ ଦେଇପାରିବି
ଏଇଠି ଦେଖନ୍ତୁ ଏଇଠି ଯୋଉ ଲେଖିଲେନି ଯୋଉଟା ଏଇଟା ପଢୁଥିଲୁ ନା 400 ଡେସିମେଲ ରୁ ଦକ୍ଷିଣ ଦିଗ ମଧ୍ୟରୁ 117 ଯୋଉଟା 170 ଯାହା ବି
ଆଜ୍ଞା ଆଜ୍ଞା
ଏଥିକୁ ଚୌହଦୀକୁ ପଶ୍ଚିମକୁ ଓ ଉତ୍ତରକୁ ଏହି ପ୍ଲଟ ନମ୍ବର ସମ୍ବନ୍ଧ ଭୂମି ଦକ୍ଷିଣକୁ ରୋଡ ଭୂମି ଛାଡି ଅବଶିଷ୍ଟ ଭୂମି ସମ୍ବନ୍ଧ ଏଇ ପୋର୍ସନ ଟା ଦେଖେଇଦେଲେ
ମୁଁ ଦେଖେଇଦେବି
ତ will take it up tomorrow or day after?
ନାଇଁ ଟିକେ ଡାକିବାକୁ ପଡିବ ସେ କାରଣ ସେ ମ୍ୟାପ ଟା ସେ ଏକ୍ସାକ୍ଟଲି କହିପାରିବେ
Leave this matter next week as per for. Otherwise it will be difficult for me to understand.
ଆଜ୍ଞା ଠିକ ଅଛି
ପଢିକି understand କରିବା very difficult ହବ
ଠିକ ଅଛି
ଆଉ ଦୁଇଟା matter ନବା
Item number 18.
The defendant number 1 is the appellant. The suit is for
amicably.
The suit is for pre-action.
He has filed an IA. All right. He has filed an IA.
And another connected appeal also filed by my senior. Then the same judgment may be tagged together both the appeals. One judgment, 2 appeals filed. And that is RSA number.
So we'll take it up tomorrow then.
Both the appeals may be taken up together. So it will be easier.
It will be easy.
Tomorrow.
This is already in the list. No, this is already in the list. Execution proceeding କେବେ ଅଛି?
20th June.
20 June ଖାଲି ନବ ନା କଣ?
Approval ପାଇଁ ଅଛି କିନ୍ତୁ execution case କିଛି sale deed number 180 of 2003. So the sale deed has been directed to be executed. It is posted to 24 Monday. Your lordship can take up tomorrow or day after as per your.
No, tomorrow because it's already in the list. I will just call for the other file.
Again.
That is ama assignment to habo.
Yes.
You see, if the court finds any substantial question of law, it will be admitted since all of you have appeared. It will be easy. We'll call for the LCR. And whatever interim order requires to be passed will be passed. This is the second appeal after all. Isn't it? Sira ko call for diyantu. More କିଛି order ଦବା ଦରକାର ନାହିଁ. ଏଟା ଖାଲି ପାସ୍ ଓଭର ରଖ ପାସ୍ ଓଭର
Maybe call tomorrow.
ଇଲେ ପାସ୍ ଓଭର ତ ହେଲା ପାସ୍ ଓଭର ହେଲେ କାଲି ଆଉଥରେ କଲ୍ କର
Item 19.
Well, may I interrupt?
Yes.
Item 25, my learned friend is there for the respondent. Well, can it be 2 weeks after?
I will not take it up today, of course. Item
25.
2018 matter. All right. You have taken the consent of other side?
Yes, sir, I will.
Item 25, leaves this matter in the week commencing first July. 1st July.
Can it be on 15th July?
All right, 15 July, as paid for.
Well, there is a
The interim order will be extended.
Interim order to continue.
there is a connected appeal. RSA number 382 of 2019. That may be taken up.
ଏଇଥିରେ ଏଇ ୟା ସହିତ
ଗୋଟେରେ ପୁଅ କିଣିଥିଲେ ଆଉ ଗୋଟେରେ ମଦର କିଣିଥିଲେ ସିମିଲାର
This is matter in the week commencing 15th July along with
RSA number 382 of 2019.
382 of 2019. Interim order shall continue. Yes, Ms. Mahapatra. I will not take up today. It's a Monduku question. Time to know the Monduku. You are there. Item 24. Tell take care of you. Pattern as the admission as for you. Item 19.
Yes,
Yes.
19. Here, in fact, it's a dispute of landlord and tenant.
Yes. You are the landlord or you are the tenant?
Tenant.
You are the tenant.
Tenant, kindly have a glance at the cost title. The appellant numbers 1, 2. They are husband and wife, and the 3 is the
partnership firm.
Or who have the tenants in this property. Now there is an agreement dated 2/9/2019.
Is it a registered firm?
Firm, there is no dispute. I don't know exactly whether registered or not, but it was operating.
There is a bar, I think, to file a suit. There's a bar 62.
No, registered partnership. No, we are not with the dispute between the partnership.
I'm not got into your matter. I'm just.
Yeah, there is a bar. If it is between the dispute between the partners, if it is unregistered, only except dissolution of partnership, no other suit is maintained.
I think it is 62 or something like that.
Only dissolution of partnership is maintained.
So what happened? You are the tenants.
Tenant. Now the landlord is
Gopalakshmi Mishra, Shiva Prasad Karo.
Again, they are
Yes,
also husband and wife.
Priya Behra.
My friend, he is also, himself is a party.
Yes.
Name is appearing. Now, agreement was executed on 2/9/2000.
Sir, you are yourself a party.
Period with your, if you kindly permit me, then I am practicing advocate as an presently.
Then you will have to open your band.
Thank you, oblige.
You will have to open your band and today, not necessarily today. Today, I think
I'm really obliged.
ସେ ଆମ ଆପଣଙ୍କୁ ଏଇନା ଶୁଣୁନି ମୁଁ ଶୁଣେ ଆଡମିସନ ପାଇଁ ଯଦି ମସଲା ଥିବ ଆମେ ଆଡମିଟ କରିବୁ ନା
Yes,
ବ୍ୟାଣ୍ଡ ଖୋଲିଦବୁ
first for the
ବ୍ୟାଣ୍ଡ ଖୋଲିବ ନା ବାହାର ଖୋଲୁନାହାନ୍ତି ଏଇଠି ଖୋଲିବ
Millard move. I don't have the
ସୁବିଧା ଖୋଲି ଦେଇ ପଳେଇ ଆସ
sorry that please excuse me.
young people are watching sir
decorum.
This is a court maintain quorum. Yes, Mr. Masu.
So the agreement was executed on 2/9/2019. The date is also admitted, and it is for 5 years is also admitted. Now the agreement is in subsistence also, because on September 2024, and the tenants also agree they will leave after September. What happened? The dispute cropped up relating to payment of rent, etc., etc., etc. The plaintiff now claims that in 2/9/2019 agreement, the monthly rent was fixed at 4 lakhs rupees, which is disputed. Plaintiff comes forward with a plea that the original agreement was with us. On a particular date, the defendants with some hooligans, they came forward, snatched away the agreement, torn it, and placed it torn pieces with me. Thereafter, we have joined the torn pieces and have those which has been executed also. I will show it. After joining the torn pieces, we have filed the suit. That is being disputed. Now, the defendant claims that it is not the agreement which was executed for 4 lakhs rupees, the monthly rent is only 1 lakh. That is the sole dispute which can be considered in this appeal.
But Mr. Bhanti, can it not be amicably settled through mediation?
ମୁଁ ତ ମନା କରୁନି ସେପ୍ଟେମ୍ବର ବା ଲାଷ୍ଟ ମୁଁ କହୁଛି ସେପ୍ଟେମ୍ବର ପରକୁ ବି ଯିବନି ଗୋଟେ
And all this. What do you say?
even I have
Really, kind lordship to just to give me a chance to present the case.
No, I will, but before that,
Millard, everything will fail. Just let me start. The Sur scheduled property is a 3-star hotel situated in the midst of the state capital, surrounded by all the 4-5 stars hotels, Mayfair, Crown, Swasti Plaza, Sandy Deserts, all are counted. This is the oldest hotel since 1909. And me, the husband of the who is a pro forma defendant, was a Nalconian, all along placed out station of the duty, out of the station of the state. And me, actually, I am the owner of the land and building since 1987, prior to my marriage. I got married in 90, and since 99, when I was in the outside of the state, and under the guidance of CDA rules, Code of Conduct, Dismissal, Central Order, I cannot own any business, and I was all on outside.
so, sir. Probably you are going on the wrong way. I have posed a simple question. Looking at the dispute as Mr. Mahathi has placed, the court feels that this can also be amicably settled.
No, Millard. Why?
All right, then we will hear the
Millard, the present, the decretal amount are today is 5.37 crores.
I am saying that is all the more reason it should be settled.
Out of which 64 lakhs is towards the GST payable to government.
Sir, that is all the more reason why an attempt should be made for settlement, but I am not going to force you. If you don't agree, then I will look at, I will only hear Mr. Mahathi.
Whether there is substantial question of law.
Yeah, that you will satisfy it. You cannot participate on that aspect. You can participate only when I will pass an interim order, then only you can pass. Then I will let me hear Mr. Mahathi first. If there is any substantial question of law,
yes,
we'll take it up. Acha. So what is the
so the torn agreement which was claimed that it is the original agreement that was placed for evidence, and it has been marked as exhibit 1 also. I will place it.
ଦରକାର ନାହିଁ କୁହନ୍ତୁ କଣ ହେଇଛି
ଦରକାର କାହିଁକି ହବ anyway at the stage of the suit it continued with no other document, and ultimately suit has been decreed holding that the agreement is for 4 lakhs rupees, monthly rent for 4 lakhs rupees. Appeal, I file appeal. In appeal, I file an application on Order for Rule 27 three documents were sought to be adduced. One document is the permission or the license obtained from the GST for running of the hotel, where the original copy of the original agreement was produced. This agreement was executed in the 2019. Few days thereafter, the document was produced with the GST. Now, I will also from the exhibited document from the side of the plaintiff that the date on which it is claimed to have been torn, it is subsequent to that application which was filed before the GST. Now, I have also annexed those documents to my application for stay. Kindly have a glance. Just to compare only, I have agreement. It is the annexure. IA annexure page annexure 1 to my IA. This has been obtained under the Right to Information Act. Page running page 10, the amount is 1 lakh rupees.
Yes.
At least during the stage when this agreement was produced with the GST government authority, there was no dispute. Now the claim is a torn pieces have been added and it has been produced with the, whether the torn piece of the last portion or the portion where the rent has been mentioned is the original one or the subsequently it has been created, that is a different issue altogether. The learned lower appellate court, kindly have a glance, whether he has considered at all this application, that is a great illegality. Page running page 20, internal 9, running page 22.
Yes.
There is a sentence about 6 to 7 lines from the top. It is further argued. This is the submission which has been noted by the learned lower appellate court. It is further argued that as the plaintiff is not the true owner of the suit property, she filed the suit only in order to harass the defendants, and that the documents obtained under the RTA reveals that appellant number 1 submitted the copy of the agreement executed between the parties on 2/9/2019 along with the electricity bill, and in the electricity bill the name of the respondent number 2 is mentioned, and that the appellant never gave threat to the respondent so. So there is reference.
There is no reference to the agreement.
Agreement is the documents.
RTA Act reveals that appellant number 1 submitted the copy of the Asha.
All the documents are obtained under the RTA Act.
All right.
So there is a reference in during the submission, recording the submission. This
what is the finding?
Pardon?
What is the finding then?
No finding, no discussion. Last line, kindly have a glance at the page running page 33. Running page 33, internal 20, the last one paragraph. Any other application petition pending in this area disposed of accordingly.
So your application under Order 41 Rule 27 has been disposed of in this manner.
This manner. No reference, no discussion, nothing. Whether it is because Order 41 Rule 27 clause B clearly says, irrespective of the fact whether it is proved with the trial court, produced with the trial court or not, the learned lower appellate court as a court of fact has to consider whether it is relevant for the purpose of this dispute, and it is can be disposed of on that basis. I am producing a document, the original one or the copy of the original one which was produced by the government authority. And during that period, the
non-consideration of this material evidence is the substantial question of law. All right, we'll admit it on that ground. But since he has already appeared, we will. I'll fix a short date. I'll fix a very short date and we'll dispose of.
Maybe 26 or 28.
Dekhiye.
Milord, just can I place something?
Yes, please.
The defendants in their written statement under para 7, in their objection under para 7, in their evidence in under para 4.
May I just request my land? There is an application for stay of the execution case which is fixed today. If a lordship is admitting the appeal, and
I will stay.
I will stay. May I take leave because number 20 have been called.
Yes.
Let me place the issue also.
No, you cannot place the issue, sir. You don't. Please, you are probably not getting the mind of the court. So far as admission is concerned, I am going to admit it. There is no non-consideration of the material document. So far as stay of execution is concerned, whatever you want to say, you may say.
Milord, as on date, I'm supposed to get 5 crores 27 lakhs from them. From
Yes.
date of the execution of the agreement. I have not got the security money as on date. I'm a retired employee. I've been
All right, sir.
number one.
If the court finds prima facie,
Okay, Miller,
Shuni sir, if the court finds that prima facie there is a ground to admit the appeal, and if what he says is found to be correct, then what will be the effect? The matter has to be remanded. This is a case which has to be remanded. Yes, if it is correct, obviously.
In the appellate court also, they have not filed any agreement. They had simply put a petition and they are going to place a third set of agreement. That was the third one. Another 2 sets of agreement they had placed in one CMC case. In
So that
another,
factual aspect is to be dealt with by the last court of fact, not this court. The substantial question of law is that with non-consideration of that material evidence.
exactly.
Anyway,
Now, in
that's
the
it.
WS, they have stored in the WS in their running page 6. They have admitted and stated the original rent agreement is with the defendant.
That is why I will grant you opportunity.
Kindly again, Miller, actually I'm an Alconian, so I'm placing me.
You are a
I'm basically retired Alconian.
Nalco?
Nalconian.
Nalconian mane?
Nalco retired employees. So I have taken all the good advice from High Court, but
No, you are free to make your argument. But the question is, you have to make the argument on the point that is required by the court.
just right now you can know that they are having 3 sets of agreement on different dates. I'm having the certified copy also. In their WS.
Sir, सेटा सुनिबा. Since you have already appeared, and I will fix a short date as you are requesting, I will definitely fix a short date. We can hear the entire appeal. Then let the LCA come.
Miller, see, I'm not going to state, I'm eviction to stay. I am staying in the same hotel in a top floor. They are making physical attack.
So for that, you can approach the police.
Miller, up to governor, the governor, the interview, I have also all the exhibits I have got. The
governor, Mr.
after the interference of governor, on this, there another advocate is there who has also come to my rescue in the court. Organized accident.
Governor go to order
7th February.
Heard Sri DP Mati, Learned Counsel for the appellant.
Agreement
Judgments. So, considering the submissions and the grounds raised in the appeal, the grounds raised, the appeal is admitted on the following substantial question of law: whether the lower appellate court was correct in completely ignoring the in not considering the additional evidence sought to be adduced by the appellant, despite referring to it in the judgment. Sir, your good name?
Mr. Shiva Prasad Karo.
His name
Sri Shiva Prasad Karo. Bracket respondent number 2. Respondent number 2 appears in person. So on the one notice jibo.
Miller. को दे दो ची 3 और 4 को नोटिस नहीं दिया ची. अब 1 पे कैबिनेट थिले हम कॉपी सॉल्व कर दी ची.
1 पे कैबिनेट किम थिले.
से कैबिनेट फाइल करसले 1 पे. One is the plaintiff in the trial.
He cannot be both the lawyer as well as the party. But if you are yourself the party, then you can appear only for yourself. You can also appear for others. For that you will have
to vacation. So I
doesn't matter.
On 3 different. ମାନେ ଏମିତି କଲେ 5 ବର୍ଷ କାଳ ମୋର ଶାସନ ଚଳି ଖାଲି କେସ୍ ଡ୍ରାଗିଂ କରି
କିଛି ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି ସରିଯିବ ଏଇଠି
ହଜୁର ନେକ୍ସଟ ମେବି ଆଫ୍ଟର 8 days
ତାପରେ person on whom copy of the appeal memo has already been submitted. Issue notice to the other respondents by speed post.
Right.
Making it returnable. Making it returnable, fixing a short returnable date. Because it's be filed by tomorrow.
My
Peremptorily.
Right.
List this matter. I'm going to short date ko.
First July.
Out again. In the week commencing 8th July. आइए 629 of 2000 that approval LCR be called for that all the court below is directed to transmit the LCR by special messenger so as to reach this court before the ensuing date positively. Hello. आइए 629 of 2024 there shall be stay of further proceeding in execution case number 40 of 2024 pending in the court of so and so till the next date. Next date execution case stay rehla week commencing 15 re the matter will come on that date will be disposed of. 15th August July.
urgent circular because the case is posted to today.
Urgent circular copy be granted on proper application. Yes. Don't worry, sir. Don't worry. Don't worry.
This way they're dragging the case.
I have already mentioned in my reflection that we'll evict by the end of September.
Yeah, that's a different matter.
You applied court also. Also they are not produced any document.
All right.
Till date.
Yes.
Petition
Item 19 Sarla. Item 24 you were mentioning, Ms. Mahapatra. What do you want? I get it.
I want time, my lord.
Item 24.
Okay.
24 is 2007 matter.
No problem.
Next week, as well. Next week,
Okay.
as requested by Ms. Mahapatra, list this matter next week. Yes.
22, 2003 matter.
Next week.
Over again. 28.
As requested by Sri Balkrishna, list this matter next week.
Let's item number 20.
28. It is 21 no matter. August.
Why August?
August. Thank you, Mukauchi. I'll be operative most probably on first, second, third, say first week. Hore roye podi mate tine week. Na.
The पूर्व सर्व नांती?
ना आज्ञा पांचटा consultant अछंती different what cardiology, neurology, all this. पांचटा को agree हेले हबो. तापर दी जन agree करलेनी और तीन जन अछंती. Only I cannot be admitted.
Item 28 कर दियो list this matter in the week commencing 12th August. Yes.
Interim order to continue.
Interim order to continue.
Yes, item note 20 next week.
Item 20.
Lordship.
2003 matter.
Lordship, Mr. Das will appear. He's unwell. That's why he left from the court. Next week, you'll find.
It will come tomorrow. It is in the list. It is in the list.
Lordship.
So I'll simply pass over. So tomorrow he can appear.
Lordship, for final hearing matter, Lordship will file the notes.
Sir, this is final hearing matter.
Lordship.
You can, after making an argument also, you can file your note of argument.
Will this come next week, Your Lordship?
No, next week. 2003 haboni, pass over. Yes, I can go on passing it over for 2-3 days.
Lordship.
But no, I will not adjourn it. Yes. Any other thing?
Obliged, Lordship.
All right. Mr. Das, that transfer matter which I have just allowed them, that Mr. Mananjan matter. I think it will be better for you to inform the concerned state council. I will also inform.